One submission.
Memo for withdrawal, my lord. The parties have settled the dispute.
Take the memo.
Tomorrow,
Yes.
parties
Memo-
travel from Calcutta, request for tomorrow, my lord.
My lord, memo for being spoken to, my lord. We have moved the matter twice, my lord.
Why it is not coming when it's specifically saying that for being spoken to should come next day? Hmm? I think that bundle, that file is not available. That's the whole difficulty. Otherwise, all for being spoken to should come next day. That's the general instructions. Yes,
It is 2819 which was disposed on Friday. They are not complying with the order saying that the order is not available, neither online or certified copy. So
how do you expect the court to,
I understand.
when was it on a Friday?
I understand.
Where are
that.
we today?
I understand. In fact, that was my very apprehension. I have committed, I have paid the money for the month of July as well. Immediately I have paid. Yet they are not complying.
Today it will be uploaded because they have to type it. Friday in the second half it is done.
There is something.
What is that?
That I have made my payment also towards the maintenance of the month of July.
That is not relevant now. Court will pass orders. Yes,
Page wise
Madam,
amendment, page
One
one.
minute. Case is reserved for orders, madam.
yes, it will
Yeah.
come. It will come this week.
Family court, you are directed.
It will come this week.
Okay, thank you.
Yes.
Page one, cell number 1 to 4. Page 2, 5, 6. Page 3, 7 to 11. Page 4, cell number 12 to 19.
My lord, serial number 13 months. Grant as an adjournment. my lord.
Which
Tell-
one?
Yeah, you
Which
will-
case?
My lord, need to file an additional,
Which one?
serial number 13, my lord.
Serial number 13.
Yes, my lord.
You are for the,
Petitioners, my lord.
what is the additional document that
Documents
to
need
be
to
filed?
be filed.
Huh?
Need to file the IA, my lord.
When do you want?
Any day in the next week, my lord.
Post this matter on 23rd
Much
at
obliged.
the request of land counsel, the petitioner. Yes.
With your
Page
lordship's
number-
kind permission, serial number 5, I'm filing memo of withdrawal minutes.
Cell number,
Serial number 5
Serial number 5.
for the
The
petitioner,
memo is,
for the petitioner.
the memo is 5. As both the children have attained majority, as the present petition do not survive for consideration. Hence, the same may be dismissed as withdrawn. Accordingly, memo is taken on file and the petition is dismissed as withdrawn. Yes,
Much obliged.
page number 5, cell number 20 to 25.
20.
20 to 25. Page number 5.
Hmm.
Page number 6. 26 to 32.
My lord, serial number 28, madam. I appear for the respondent. I have already filed wakalat last week. Maybe posted next week. There was one more order has been pronounced in the lower trial court. So even let me produce even that document if it is possible in the next week.
We will
Regarding-
decide this application.
Subsequently, we
your
have filed an
file.
application for police assistance. So the court has not granted that one. So even we get this. Yeah.
As far as this FC is concerned, it can be decided. You can question that later.
Yes, madam.
And you know what is the order?
Yes,
No
yes, yes,
objections are
madam.
required. You file your wakalat. we'll
Yes,
hear
yes,
it.
madam. Yes, you.
Yes, next.
7, 33 to 36. Page 8, 37 to 39. Page 9, 40 to 43.
Ladyship, serial number 40. There was a direction.
40?
40, 40.
Huh.
There was a direction for the matter to be taken up in chamber. If your ladyship recollects, this is the case where the mother travels from Gwalior. I am appearing for the father, respondent father. She has traveled. There was a visitation arrangement that was made by this honorable court, and she has traveled to Bangalore along with the child. There was a
Oh, that's the case. Earlier, the court had interaction.
there was a direction to be.
Then why it is not listed like that?
The file sent to the school, you can just go to the people have listed like this.
She's here.
She's traveled.
Can it be tomorrow?
She has traveled.
Can it be tomorrow?
I'm unaware of her ticket booking, your ladyship.
No,
The visitation arrangement was prior to the.
No, because now the difficulty is already there are two matters today. In the afternoon as well as in the evening. And evening there is a meeting for me. Please find out from the client if it is.
I'll confirm with the petitioner.
Whatever it is, yes, yes.
Cell number, page number 10, cell number 44.
Yes, follow
For
this.
order- For dismissal, cell number 1, Rahul S. Reddy for
Very for the
petitioner.
respondent in this case.
Appealing for the petitioner.
Yes.
But in this case, my lord, case before the trial court is for dissolution of marriage, my lord. They are also seeking, there is a settlement held because of some discrepancy with regarding to the adverse order passed against the petitioner advocate, my lord. The said petition came to be filed, my lord. The matter may be referred for mediation because, my lord, it is pending since 8 years now.
Yes, not necessary for a interlocutory application of 19 penny year.
My lord,
Mediation rights has been granted, my lord.
Yes, yes.
The matter may be referred for mediation. The petitioner, respondent is present before this honorable court.
My lords, herein the matter is the petitioner number 1 is a wife, my lords, and the petitioner number 2 is an advocate and record for the petition number 1, my lords. My lords, in page number 35, my lords, when the case was going on,
35,
page number 34, my lords. From the last paragraph, my lords,
yes.
advocate for the petitioner has objected when intimated her regarding the terms of settlement. Though court has not directed the petitioner to quit the job, advocate for the petitioner started saying that petitioner is not going to quit the job.
Sure.
She is the only earning members in her family and has to look after 3 members. This is the third time settlement arrived at between the parties and the court has to be proceed to record the evidence. Once again, advocate for the petitioner started submitting what all happened in this case during previous settlement. Further, advocate Sharda for the petitioner directs the court to proceed with recording evidence of the respondent. This shows that the advocate Sharda for the petitioner is interfering when parties have agreed for particular terms and object for settlement. Advocate for the petitioner has also questioned the petitioner as to whether she has said to the court that she is accompanying the respondent. On the other hand, respondent expressed happy for having arrived at settlement. During this development, petitioner started crying. This shows that the advocate Sharda for the petitioner is too much interfering with settlement is going on. Hence, in the interest of justice, her service has terminated. My lords, my contention is wherein
Exactly
the
for this reason, I'm sorry.
learned judge has terminated the wakalat of the petition number 2, my lords, wherein, my lords, the learned judge cannot do that. She can issue a contempt against the petitioner number 2. And my lords, only the petition number 2 has a right to terminate her wakalat, which she has not done. Though she is a party over.
Please come, these kind of orders come. Please come. Agreed with the order dated. And what about the mediation thing? What do you say?
Mediation may be referred before
Yeah.
a trial court.
Okay, see, for exact for this reason, I'm preferring settlement here, my lord, because in Bangalore mediation center is one of the best, my lord. In Tumkur, again, this kind of interference will take place, my lord. Again, the litigation will take place, multiple.
So
Yeah.
how the party has to come from Tumkur to Bangalore?
Tumkur, my lord, it's very near.
No, but why should they come when the mediation center is available there?
But here, my lord, it's very.
No, either way, it's either at Bangalore or,
Again, it is
no,
already.
no, either at Bangalore or Tumkur, people can't compel the parties to compromise.
No, But I
Ultimately,
requested,
what-
I request.
No, 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 what problem you will get here, the same problem you will get here.
But
Let it be, let us not, when there is a mediation center available there, why should we?
my lord,
please.
For regarding the merits of this case, my lord, for the argument made by my lord sister, my lord. This petition, my lord, the advocate is permitted under section 13 of the Family Courts Act, my lord, exclusively on the discretion of the trial
No,
judge.
these kind of orders passed by the court, being an advocate, you also understand.
I can understand.
So
Absolutely, I
let
can
there not be
understand.
these, we'll set aside this
Would
order.
have been better, my lord, if the mediation could have been referred by this
Yes.
honorable court. It would have been more solemn, my lord, here.
No, we will set aside this order and refer to the mediation
Kindly.
at Tumkur, not in
Kindly.
Bangalore.
Kindly.
The agreed with the order passed, agreed with the order dated 22/2/2019, whereby the court had terminated the services of the petitioner advocate. The present writ petition came to be filed. Then counsel for the petitioner submits that without any basis and contrary to law, the order has been passed by the learned judge. It is submitted that if at all there is any interference or any interference, then the court could have initiate the proceedings for contempt of, when the contempt that the advocate is interfering with dispensation of justice. But the court cannot terminate the services of the advocate. And it is not even the case of the client that she is interfering. The advocate is interfering with the settlement or any of the issues. Even for coming to such a conclusion, the court in one line cannot pass such an order. It is submitted that the order is liable to be set aside. Land counsel appearing for the respondent submits that as there is continuous, as in spite of, though the parties were interested, and still the advocate was opposing, the court was compelled to pass this order. Next, having heard the land counsel for the petition, having heard the land counsels on either side, there is a material on record. This court has observed that by way of a cryptic order, saying that the advocate for the petitioner, advocate, the parties have settled, but the advocate is interfering. And not permitting the parties to settle the matter. The court ought not to have passed such an order terminating the services of the advocate without even, without recording reasonable, and without there being a material before the court. And if the advocate is, the client is not happy with the services rendered by the advocate, it is always open for the client to seek a no objection from the advocate. And if these kind of orders are not in the interest of the bar as well as the party, considering all that, the order dated so and so is set aside. Next para. Land counsel for the respondent submits that there is a likelihood of settlement, which the land counsel of the petitioner also do not deny the same. Considering the same, the parties shall appear before the Tumkur Mediation Center on this month or next month?
This month, next week.
On 22nd. On 22nd, yes. Registrar Judicial is directed to communicate the same.
Much obliged. Cell number 2, preliminary hearing B group. K. Ravi Shankar, petitioner. Sachin.
Let I have alternatively a submission. This matter may be tagged along that petition because the interim maintenance is also involved in this. There is also a permanent element. Therefore, the same parties, with regard to the quantum of maintenance, I request this court to tag on that before the division bill, so that it can be disposed of simultaneously.
No, what is the issue that arises before this court?
This
You
court
wanted
is under
stay of all
section,
further proceedings.
please,
You wanted stay of all further proceedings.
for the further proceedings, that is also arising out of an 125 proceeding seeking maintenance. That is also under the section 24, a permanent elimine has been granted. Both issues are interlinked.
Interim maintenance she is seeking.
Please,
This is interim
interim
maintenance.
maintenance.
Had this writ petition been heard long back,
I will address her.
she would have had some maintenance. Some interim maintenance till permanent alimony is granted.
No, from the date of the inception, no interim maintenance, no application has been.
Anyway, she sought it now.
But I
That
would
gets
argue
decided.
them.
Huh?
Let me.
Yes, argue. Let's see the order
Yes,
review.
Let the all rising page number annexure E page 40.
Page
This
40.
is arising out of an application under section 127 of the CRPC seeking to rescind the proceedings. The reasons starts, may I read from the.
Yes, it's
starting.
from the beginning we'll read.
Yes, para 2, in this application, the respondent has stated that she has earlier filed a petition under so and so for a dissolution of the marriage and the petitioner. Herein, and the honorable court judgment and decree dated allowed the petition by dissolving the marriage. At the same time, awarded permanent alimony of 28 lakhs to the petitioner. Hence, the he filed MFA number before this Honorable Court, Honorable High Court of Karnataka at Bengaluru, challenging the judgment and decree in respect of the permanent elimination part, and the Honorable High Court issued interim stay order dated 21/9/2020 and directed the respondent to pay a sum of rupees 7 lakhs to the petitioner within a period of 6 weeks from the date of the said order. Therefore, the respondent paid 7 lakhs to the petitioner by a demand draft dated so and so, so and so, so and so. And the petitioner, in spite of receiving the notice in MFA by the Honorable High Court of Karnataka, he has neither preferred an appeal nor appealed before the Honorable High Court, nor challenged the interim stay order by in the MFA. Further, he states that the application that the petitioner suppressing the fact that granting of permanent alimony to the tune of 28 lakhs and thereafter the receipt of 7 lakhs from the respondent has filed the petition seeking maintenance. Further, he states that the wife who has granted the permanent alimony under Section 25 of the Hindu Marriage Act cannot seek maintenance under Section 125 of CRPC, and therefore, under the changed circumstances, he prays for a dismissal of petition by the petitioner. The petitioner has filed objection. Next, reasons. Next page 43, para 6. The main contention of the filed by the petitioner seeking direction to this court, respondent to pay the monthly maintenance of 50,000 to the petitioner, and the case stands posted for recording of respondent's evidence after close of the petitioner's evidence. At this stage, this instant application is filed by the respondent seeking dismissal of the main petition under Section 127(2) under the changed circumstances in the said application. The submission of the learned counsel for the respondent applicant is a main object of 125 is to provide immediate relief to the applicants to be destitute wife and the parents or the children of the respondents or their survivor. Here, in this case, the wife has been awarded 28 lakhs permanent alimony, and admittedly, out of the said amount, 7 lakh is already paid to the petitioner herein, and therefore, the petitioner is not a destitute wife struggling for her survival, and she further argues that parties are no more husband and wife and they have no children out of the wedlock, and the respondent husband is also human trying to hard to survive, and he cannot be allowed to squeeze by the wife according to her whims and fancies. She further argues that so seeking permission to court alter the objection so and so filed by the husband and include a counterclaim for the permanent alimony which was rejected by this court, and she had filed a writ petition before the Honorable High Court against the rejection of the permission to amend the suppressing the fact pendency of in the instant petition seeking maintenance, and hence nothing in this fact. The Honorable High Court has dismissed the writ petition, slapping 10,000 costs upon her for not approaching the Honorable Court with the High Court with the clean hands. She further adds that the petitioner being the attitude in filing one of the other cases only to squeeze the respondent and harass him. Finally, he argues so and so. Judgment, para 7. For contra, let the ranges and everything is been quoted. The reasons, para 8. As rightly pointed out by the learned counsel for the respondent husband, 125 provides for a speedy and effective and inexpensive remedy against the persons who refuse to maintain or neglect to maintain the persons legally dependent upon them. A wife who is unable to maintain herself and her husband who also sufficient means neglects to refuse to maintain her may make an application under Section 125 of CRPC and seek an order of maintenance. Undisputedly, the petitioner has filed the petition seeking maintenance when the petition filed by the MC seeking dissolution of their marriage was pending before this court. Hence, the first and foremost contention that the respondent that the petitioner herein was suppressed the fact of granting maintenance permanent alimony of 28 lakhs and her receipt of 7 lakhs from the Karnataka does not hold water. True, the Honorable High Court has slapped the petitioner with the costs of 10,000 while dismissing the writ petition filed by her against the order of rejection of amendment application, which was filed her subsequent to filing of so and so, seeking maintenance by suppressing the same. But this case was filed by her before this Honorable Court much prior to the judgment and the order passed in MC number so and so. And hence, there is no question of suppressing the said fact before this court. Now, coming into the claim of the change in circumstances, here the judgment and decree passed by MC so and so is challenged before the Honorable High Court of Karnataka by both the parties herein with their respect to their respective claims. Therefore, the order of the court dissolving the marriage between the parties does not attain finality on the sole ground that the appeal continuation of proceedings of the lower court and also the order of granting permanent alimony. Admittedly, the parties are in dispute since 2016 and the petitioner has received 7 lakhs from the respondent in 2020. The contention of the learned counsel for the respondent is that since it was paid under 7 lakhs by the respondent, she ceases to be a destitute and there is no more in desired necessity of money for her survival. The object of 125 is to provide immediate relief. The Honorable Supreme Court has time and again explained the meaning of the scope of survival and also held that even the wife is earning, it cannot operate as a bar from being awarded and maintained by the husband. The court has to determine whether the income of the wife is sufficient to.
This has seen,
Yes. Now, kindly similar section 127 at the first instance. CR. One 127 CRPC.
yes.
Clause 2. This is alteration in allowance, where it appears to the magistrate that in consequence of any decision of a competent civil court, kindly mark me, any order made under subsection 125 should be, the word is should be, cancelled or varied, or he shall cancel the order or the, as the case may be, vary the same accordingly. Therefore, the section postulates it's incumbent upon the magistrate to pass any orders. Look, I have demonstrated before the court that the permanent alimony of 28 lakhs has been called in question. Now the writ at large is before the MFA court. 7 lakhs are already been deposited on showing before the court and prima facie that the amounts awarded by the trial court itself is exorbitant to the petitioner. Now, as of now, 7 lakhs has been filed. No application for modification of the interim order is filed before the MFA, nor they have filed an application to seek any further maintenance is my first submission. Secondly, the second 125 deals with, it's an immediate relief for a destitute wife. So far, the case before the trial court is posted for evidence. No application is filed for seeking maintenance for her survival is cannot be done. Now, the case at that stage, this application is filed to resign. Thirdly,
Whether she is a destitute or not, whether she is in requirement of money or not. If you let the court to pass an order, it will
what
pass it.
prevented the wife from filing an
All those
application?
things on the merits of it, court will decide in this
Let-
application.
Correct. But now the court holds that it requires even after giving 7 lakhs, I cannot scuttle down the proceedings. But the 127 says it is incumbent upon the court, trial court should take into consideration to vary and alter the maintenances, where it appears to the magistrate that in
What is the relief you see sought is to reject it.
reject it.
Not to decide that whether how much is the what is the maintenance.
Now
You
the
need to ask-
maintenance is not granted. Maintenance order is not granted. So as to order, I have sought to rescind the proceedings on the ground that there is an order. When an order is made, judicial proceedings are produced before the trial court and this court's order by an interim order. You lost my credit in page number of the writ petition. 125.
Your IA, what did you ask for?
Yes. Page 34.
34.
34.
Yes.
All I have said, Millard, I have paid 7 lakhs, therefore rescind the order. 28 lakhs, there is a decree. Para 3. The Honorable High Court of Karnataka in its interim order dated 27/9/2020 has stayed the impugned judgment and decree insofar as so and so payment permanent alimony is concerned, subject to the respondent in this case paying the petitioner in the case 7 lakhs within a period of 6 weeks from the date of the said order. That the applicant responds.
This application is filed much prior to the disposal of the MC.
Please, Millard.
This application is filed much prior to the disposal of the MC.
No, in the MC itself, it has been granted.
No, this 125
Application, Millard, it is 19.3.
filed much prior to the MC.
No,
The
after the
question of-
disposal,
After
The MC, one second.
The pending MFA case, this interim for maintenance, section 125 application has been made.
That you have not stated about the granting of 7 lakhs.
Where, madam?
In this MC that you have filed, you're not stated about your permanent alimony and an amount of 7 lakhs that is granted in the MFA.
No, my lord. Lords, after that, my lords, section 127 will not apply in this case, my lords. The application that has been filed here will not survive in this case, my lords, because section 127 clause 1 talks about, my lords, an order, alteration in allowances on proof of.
No, I am on the facts. I'm asking you, when you filed filed this 125 CRPC proceedings, did you disclose about the permanent alimony that's granted to you in the MC and also your, 7 lakhs that is granted in the MFA?
No, my lord.
Why?
No, it was, let it not be in a confusion of state of facts. The 125 proceedings, when it is filed, this decree was not passed.
That's what I'm saying.
Yes, correct.
Even before that this MC is decreed, this is filed, that's what the court observes.
That's the
I'm
fact.
referring to
That's
that.
the fact.
Uh,
MC
So then the
order
court said question of disclosing all that will not arise in this petition.
disclosed. Now as a fact, matter of fact, between the list between the same parties, now admittedly there is a decree. Decree is for 28 lakhs. MFA, the interim order of permanent alimony has been stayed subject to 7 lakhs. Nothing prevented the wife to file an application for seeking modification. But it is a 125 proceedings is only for a destitute wife for immediate relief. No interim maintenance has been granted by the trial court by filing an application seeking interim maintenance. It is stood for evidence. Now that statement, we filed an application. Now for what purpose? When a MFA is pending, they can seek an application for modification seeking require more amount. Nothing prevented. Now why should the proceeding should be continued?
But the reason is because there was emergency situations, my lords, where we could not file an application in MFA. We filed 125 proceedings because of emergency situations. My lords.
That you have filed 125, much prior to your MC is disposed of.
Yes.
Now, once the MC is disposed of and 28 lakhs permanent alimony is fixed,
Yes.
no, this is it, not the, it doesn't remain to be the same.
Yes.
And 7 lakhs you have already received.
Yes.
So why should these proceedings be continued?
My lord, because the last amount which you have received, my lords, is in that.
No, why don't you ask the court? Why don't you ask the court where MFA is pending? No, once you have the permanent alimony, again, you can't ask for 125 proceedings. So now the court has only asked for depositing 7 lakhs. No, it's been pending from a long time. We could have asked, no, that 7 lakhs that is, that is that is deposited by them is not sufficient. So deposit another 7 lakhs so that it is pending whatever is the decision of the court. That would have been more easier way for you to deal with it. When was the MFA filed?
Lords, MFA was
2020.
2021.
No, you had like 3 years time. When was this order passed?
This also was passed, my lords.
Much after
That is because
2020 MFA.
we have filed 2020, they have filed, my lords, 2021, we filed.
You have filed.
After that, my lords, in that 2021, we got 7.
You're also asking for enhancement of the alimony.
Yes. we are
So if the court feels that what it is, it could have been decided, no, you have a permanent alimony. Now you will have 125. Then the court will confirm, this court will confirm, for example, the 28 lakhs. Then again, whatever that has been paid to you during the pendency of this, again has to be relooked
Adjusted.
into. Some order needs to be passed, which is altogether a separate proceeding, sir. Then we'll give you, now it has come up for the final hearing. If not, now even at this stage, if the things are not being decided, file an appropriate application. That I'll observe. Because anyhow, again, going back, again, this proceedings taking forward, your client will not get a relief.
It may be posted for tomorrow, my lords, seek instruction.
At the request of land counsel, the respondent. That would be the best way.
Yes.
Now, even the court, by the time they pass order, then again it will come to this court and your client will not, there won't be any benefit to her. Yes.
Cell number 3.
Number 3, I'm appearing for petitioners, my lord.
Well, Bengal,
My lord,
Ashok Kumar Shetty.
My lord,
memo of calculation.
my lord, this is the case, my lord, wherein the IA number 2 has been allowed by the trial court, my lord, wherein 25,000
So
interim
where
maintenance
is the
has been
interim
passed.
order of this court dated?
Dated 18 18/1/2023 at page number 76, my lord, which
No,
operating.
no,
court-
this court order dated. Interim order.
Dated, interim order,
There is no interim order.
4/8/2023, my lord,
4/8.
2023.
$50,000 only within 1 week, and another like sum of rupees 50,000 only within a week next following, which the wife failing which the interim order stands vacated. As for the order of this court, he was directed to pay only 1 lakh.
50/50, 1 lakh.
1 lakh.
Yes.
So why are you giving that 4 lakhs and all? As to the other day? But unfortunately, stay was granted only on that condition, and that stay order is continues to be now. You have not, the order is such, stay is on condition of paying 50 and 50. There was no direction for him to continue to pay. That 50/50 has paid. Yes, paid. No, we'll hear it on the merits of it. Yes.
My lord, the contention of the respondents.
Please come to the order impugn.
Order at page number 76, my lord.
76.
Starts from operating portion is at page number 82. IA number 2 has filed by the petitioner wife under section 424 of Hindu Marriage Act is hereby allowed, and the petitioner is entitled to maintenance 25,000 per month. Dated petitioner is fulfill further orders, and the respondent shall arrears of the maintenance so and so. This is the order, my lord, at page number 82, my lord. Prior to that, my lord, she has contended that, my lord, 80,000 rupees I had salary, my lord, but which is wrong, my lord. At page number page number 29, my lord. Page number 29, the first para, my lord. The respondent hereby denies that the fact that the respondent was working engineer at the time of the marriage, and in the fact that the respondent was and is still in working in the manager procurement in Davangere Smart City project, since it is 24 October 2017 contractual basis, my lord. And they said contract is renewed and yearly basis upon the directions and the organization. My lord, the respondent hereby denies that the fact that the respondent had a salary of 80,000 rupees per month, my lord, at the time of the match fixing and engagement of the respondent was working Bescom Bengaluru till 16th October 2017 and was earning the amount of rupees 28,000 rupees only. At the time of the marriage, in the fact that the permanent was note that the pertinent to note that the net pay of the respondent during the marriage of 41,000 rupees only, and whereby the present salary of rupees 59,000 only, my lord. In the, since it is a contractual work, my lord, the salary is fluctuating, my lord. It's not permanent salary to say this much, my lord. There is a fluctuation in the salary, my lord. And the petitioner is supposed to look after the father, aged father and mother, my lord, and his expenses also, my lord. And respondent is working in the, she was working in multinational company in Bangalore earlier, my lord, and she was.
What is the qualification of the respondent?
No, she's not working, but she's.
What is the qualification?
Having saved the 4 page only.
Earlier she was working.
Yes, my lord. Yes, my lord. She was working in Bangalore, my lord. In the petition
What
itself.
was the
she
material file?
material in this, my lord. She herself says that I have ruined her career, my lord. Prior to that, she was working in Bangalore.
That is not your contention. There should be something to show that she's working. Some evidence should be there. Just like that, whatever you say can't be taken into consideration. Child is aged 4 years and recently married. So your salary is how much?
My salary is, my lord,
As per record, just now we read
60.
it. Hmm.
my lord,
And the court also finds that you say, what are your expenses?
expenses, I have
Hair cutting per month, 1,200.
my father is also there, my lord.
Hair cutting 600.
Affidavit.
No, 1,200 for shaving and head massage. 600 for hair cutting. 1,50,000 as legal fees and 10,000 as traveling expenses for the council per hearing.
Yes,
That's what you have given. Court has recorded that.
yes, ma'am.
The
But
court had rightly granted 25,000. When you can give these money to your advocate for your hearings, you can as well give it to your daughter and wife.
my lord, what is the contention at that time, my lord? That time there was a salary, my lord. Now his condition is not that good, my lord, as of now, my lord. And what I supposed to state that, my lord, the salary she was earning, and that time she was having her own income. But after the marriage, my lord, during the match fixing, and she left the job and she is staying with the petitioner, my lord. Upon that, my lord, she can earn, my lord. She is a well-qualified person, my lord. She is,
PUC, my lord. PUC.
she was earning, my lord. I'll produce the document if at all required, my lord. She's earning. Second thing is, my lord, what I can say is, my lord, he has to look after his aged parents, my lord. Their medicine and everything. She has to look after, my lord. The reasons.
That's why three parts the court has done.
No.
For you, for your parents, for yourself.
My lord, I have to pay
Reasonably
the
granted.
fixed amount is there, my lord.
Please come. Agreed with the orders passed in. I number 2 in MC number 8/363 of 2022 on the file of the Principal Judge Family Court DK Mangalore dated 18th January 2023. The petitioner husband is before this court. Parties are referred to as wife and husband for the sake of convenience. The wife had filed I number 2 in MC, in MC number 363 of 2022 under section 24 of the Hindu Marriage Act, seeking interim maintenance of an amount of rupees 25,000 per month. It is her case that she has filed the main petition for dissolution of her marriage on the ground of cruelty. Her marriage was solemnized on 19/5/2019. And out of the wedlock, they are blessed with a daughter who is aged 2 years. And the petitioner and the wife is taking care of her. According to her, is working as a manager at Smart City Davangere and getting monthly salary of rupees 80,000. The husband filed his objection, stating that his salary varies from 59,599 to 65,778. And along with the statement of assets and liabilities, he has given the deduction and his personal expenses headwise. The court has observed that he has stated personal expenses as rupees 600 per month as hair cutting, 1,200 per month for shaving and head massage, 1,50,000 as legal fees, and 10,000 as traveling expenses of his counsel for her per hearing. The court observed that when he is in a position to pay legal fees of 1,50,000, apart from 10,000 as traveling expenses, who is attending from Thane of Maharashtra per sitting, but is objecting to provide maintenance to his wife and daughter. The court observes that the prima facie the requirement of the petitioner, capacity of the respondent by going through the pleadings and affidavits is clear. And the maintenance claimed by her is just and reasonable. Court has further observed that the wife is entitled to lead a moderate life similar to the status of her husband, even if she is residing separately. that too during the pendency of the divorce petition or any other matrimonial proceedings, and accordingly granted an amount of rupees 25,000. Aggrieved thereby, the petitioner is before this court, the husband is before this court. When this matter came up for hearing on 4/3/2023,
Yes, madam.
on
4/8/8, madam.
4/8/2023, this court has granted interim stay of all further proceedings on the condition that initially he should deposit 50,000, later another 50,000. The learned counsel for the petitioner submits that he has complied with the interim order. It is further submitted that the petitioner or husband has to take care of his aged parents, and also he has to maintain himself. And the salary that he is getting is not sufficient to take care of his parents and himself. But the court had granted 25,000 as maintenance to wife, which is highly excessive, and the petitioner won't be able to pay the same. He submits that now even he's not earning the salary as earlier stated before the court below, and the amount of maintenance needs to be reduced. Next part. Learned counsel for the respondent submits that she done her PUC. And as on the date when the application is filed, the daughter is 2 years, now she's 4 years old. She needs to be at the house to take care of her, and her constant presence at the house to look after the child is necessary. And hence she is not in a position to work. It is submitted that when husband is earning reasonably and he has, apart from maintaining his parents, he has an obligation to maintain his wife and child, which the petitioner has failed to maintain. The court below, considering all the relevant aspects, has granted the maintenance of an amount of rupees 25,000. Next para. Having heard the counsels on either side, peruse the material on record. The wife has done her PUC and she is not working. She's having a daughter who is aged 2 years as on the date of application. Now it is 4 years. And considering the fact that she is a single mother, even if she is educated, still the question of why she is not working now cannot be considered by this court. Then coming to the income of the husband, where it is 60,000 and odd. The court had granted an amount of rupees 25,000 for both the child and the mother. All the figures that are furnished by the husband as his in the statement of assets and liabilities about his expenses shows his luxurious life he is leading, and the court had rightly held that when he is able to give that much to his advocate, he can as well take care of the wife and the child. Hence, this court finds no reasons to interfere. The court below had rightly granted the.
My lord, one more submission.
Accordingly dismissed.
My lord, one more submission. Section IA number 4 is there, my lord. IA memo they filed and struck down my defense, my lord, in the trial court. That
was struck down because
Struck
he
by-
stopped paying.
struck.
No,
No,
but
my lord.
that is a separate cause of action.
No,
and
both
separate
I have
IA.
challenged. Both I have there, ma'am. IA.
The same IA is passed.
Yeah, both the same, my lord.
There was
Interim
no
order
edit.
for both, my lord. Interim order for both.
How can it be? First of all, why I don't know.
One prayer.
1 minute, when an IA is passed, when an order is passed, you can't ask 101 IAs now before the court below.
No, actually,
1 minute before the court below. For every relief you are passing, you are filing 1 IA. When it comes to the High Court, you are coming under the same proceedings. This is not a writ under 226. Now, when you're filing an application under 227, a writ petition, you need to file a separate writ petition for a separate IA.
now one submission, my lord. Just
So please come to the impugned order,
impugned order, my lord, at page number 88, my lord.
page number.
88, my lord.
What was considered is IA number 2. Then
2 and 4, my lord.
2 and
4, IA number 4 also. Annexure E, my lord, at page number 88.
no.
It is not IA, my lord. They filed a memo, the court has accepted the memo and they
It's
passed.
that order first.
It is at page number 88, my lord. At
Page
pa-
number 93.
memo dated the 6/4.
Line. Just,
No, you have questioned this IA, is it not?
yes, my lord, struck down, my lord. My defense has been struck down, my lord.
Where is your prayer, let us see?
Kindly prayer, my lord, page number.
How can the section number these kind of repetitions, so many IAs, sir? There should be a, as if this is a repetition filed under 226.
At page number, my lord. 8, my lord.
Let's see your prayer.
Prayer. Prayer A, my lord. And prayer B and C, my lord. 3 prayers are there, my lord. Prayer C is there, my lord. To set aside the ex parte order dated 8/6/2023 of striking out the
What is
defense of
this?
the.
To pass such other and further orders as deemed fit, this will come into.
No, my lord, there is B, my lord. To set aside the ex parte order dated 8/6/2023, my lord. Striking out the defense of the petitioner, considering the memo dated 6/4/2023 preferred by the respondent here.
Both of us are looking at the same page.
One submission, my lord, it was not.
Both of us are looking at the same page.
Yes, my lord.
Page number 8.
Yes, my lord.
Please look at it. What this court finds is, A is under section 24 of the Hindu Marriage Act.
Yes.
B is to pass such other and further orders as deemed fit. That's what I see from page number 8, how it stands before this court.
Is there, my lord, A, B, C. Annexure E, my lord, I have challenged.
Huh?
Annexure E also I have challenged, my lord.
Look, you see this court, this page, you show it to him.
And my lord,
Show
it
the
was-
prayer to him.
And my lord, one submission, it was
No.
not ex parte order, we had participated, there was no.
In the interim order, my lord. Here.
How can there be an interim order? What is a final order? Final, can interim order be beyond the
My lord,
final order?
What is that? That's a realignment of issue, my lord. Actually, what has happened, my lord, they struck down because of the maintenance matter, my lord. Because,
No,
because,
I'm not granting any interim order to you. I'm
my lord,
granting a
otherwise,
final
my
order.
lord, my lord, I would submit, my lord, whatever they're claiming, my lord, I'll allow me to pay that, my lord, within a month of 1 month or so. I may allow to proceed further, my lord, defense evidence is there, my lord. So that,
Counsel, you're not understanding one point.
yes, my lord.
We are not under 226 that whatever you ask, whatever you don't ask, court will grant. When the
My
matter
lord.
arises from a proceedings of the family court, you don't ask the prayer.
No.
No such IA is in question before the court. And how can there be the
IA
IA
is-
order? No. What is an interim
They
order?
didn't file IA, they just file a memo, my lord. Considering that memo, they struck down my,
Be a relief, but an order is passed.
by virtue of the interim order, my lord. Interim order court has considered the same, my lord. Kindly peruse the interim order, my lord.
First of all, what I'm asking you is,
Yes.
what the court grants the different relief. When the court is asking a question, is it permissible? First, you have to tell the court that I shouldn't have done it. Is it not?
Yes,
You
ma'am.
should have said that I should have asked for a relief, which you
Yes.
have not asked. First, once you clarify that, what this court will do, that is a different aspect.
Okay, ma'am.
No, I'm asking you, did you ask a relief, a final relief, a prayer with regard to setting aside that order of the court, wherein your pleadings or your pleadings are struck off or whatever it is?
Yes, ma'am. That is a
Did you ask?
realignment, my lord. Realignment, my lord. That is a ABC, my lord. That's what happened, my lord. Just, my lord, I may allow to pay the amount, my lord, within a month period, my lord. I may proceed further, my lord. Otherwise, things will.
That was struck down because he stopped paying, he has not paid.
The amount, whatever amount they are claiming, my lord, I may allow to pay, my lord.
How can the section also, his main prayer is something, interim prayer is something which is unconnected, and still they are numbered?
My lord, that's a realignment problem, my lord.
Huh?
Realignment problem, my lord. Actually, that was a B as a A, my lord. Actually, A, B, C is there. My C was actually A, my lord. Last one, interim prayer, my lord. That's a realignment problem.
But court can't understand your realignment problem. I can only look at this. Now what, no, your prayer is this. How can this prayer be?
My lord, by virtue of the interim order in that it is mentioned, my lord, struck down has been stayed by this honorable court, my lord. The
I can't
defense-
grant those kind
defense
of
of the-
prayers
my lord, defense of
without
the
a prayer, because there should be a procedure to the court.
Yes, my lord, definitely, my lord.
Now I can't
Yes.
consider that. I can't consider.
My lord, yes, my lord. What I am saying is, my lord, when I have.
If the court might have granted the interim prayer, that is not binding on this.
Not binding on.
No, the final order
Definitely.
which I am passing, there is
Def-
no prayer for setting aside.
My lord, that is just realignment issue, my lord. That issue may not be vitiate my entire case, my lord. I may just allow me to file whatever the calculation, memo of calculation they are filing.
Which, there is no order. Why are you not understanding that? When
No,
that is not questioned,
Tomorrow, what is going to happen in the trial court, my lord?
that you should have thought before
My
filing
lord,
this writ
my lord,
petition
this
and
is
by
just
looking at
realignment
this.
issue, my lord. Other than that, realignment issue, because of some of my mistakes or some issues, my lord, my client should not be.
I don't think that's the law.
What I am saying is, my lord, the realignment
No,
issues.
now
has been-
tomorrow, when the other side questions this
No, no.
order, that when there is no prayer, the court has granted out
no,
of the
no, no.
way. Well, how would the
My
order
lord,
will be
their
sustained?
relief is, they are seeking the 4 lakh something, whatever they want. Allow me to pay that, my lord. I will pay it by that time, allow me to defense evidence, my lord. That's what.
Are you not at least supposed to amend the prayer? Are you not supposed to amend the prayer? How can you expect the court to do all this? Amend the prayer, we'll pass the same order.
Okay, ma'am. Much obliged, ma'am. Thank you, madam.
Pose this matter next week. By the time the petitioner shall amend the prayer.
Interim order, ma'am. Much obliged.
Number 4, Shriram HC for petitioner, PM Sidmalappa.
In this, I appear for petition. Last week, the matter had come up, your lordship, last week also. Whether the appeal is maintainable, petition is maintainable or not, my lord put the question, your
Yes.
lordship. That's why I
Serial
took
number
time, my lord.
Yes.
Well,
Serial number 3, date may be given, my lord, otherwise it will not. Next week, Monday it will come. Okay.
subject to your lordships, my lord, order 47, my lord, may kindly see. Before that, my.
Order 47.
Order,
that.
section 47 of the Guardians and Wards Act 1890. Before that, I take your lordship's attention to my prayer in the petition, your lordship. That's all the prayer, my lord, page 33 in my appeal, in my petition, your lordship. In my petition, my lord, page 33.
You extracted.
Yes, no,
Please.
not extracted. In my prayer, my lord, in
Read the provision first.
before going to that, it will be helpful, my lord. Prayer is to be seen, my lord.
Page
Then we
number?
can go. Page
Page.
33, my lord.
30?
3 of my petition. GNWC case which I have filed, my lord, under 6 and 7. What is the prayer which I have sought is, my lord, below. Direct the respondent to hand over the permanent custody of the minor child Purushottama to the petitioner. This is the only prayer which I have sought, your lordship.
That's the relief you saw.
That is the relief. The more than that, I
The
can.
final relief.
That is the final relief. your lordship. Now, my lord, may kindly come to section 47A, my lord.
Yes, we'll look at it.
Shall I pass on the?
No, she's taking, I think you also you need to. Why, that is not there?
Sir, kodi nimdu book kodi.
47A.
Yes.
47A.
Hmm.
Any order passed under section 7. Subsection A is there. I have not sought anything of that kind. I have not sought that prayer, your lordship. Therefore, my lord, according to me, my lord, the writ is maintainable because I have not sought all those prayers, my lord. That's the.
It is not about the nomenclature that you use in your relief.
No, that's what.
Ultimately, what you want.
No, I just wanted to bring it to a lordship
Still, it
notice
is
whether
not.
it is possible to interpret and.
It's not, it's not.
Or else, my lord, I may be permitted to convert this, my lord, into MFA, my lord, if your lordship permits.
Use of 2025.
No problem.
File a fresh
We can
petition.
convert it as an appeal, your lordship. I can convert it.
The present writ petition is filed, agreed with the orders, agreed with the final orders passed under section 9 of the.
6 and 7.
6
Where
and
is
7.
Where is the order?
Say, order is.
Order is in page number 40. Sorry.
Annexure C, my lord. Annexure C, page 47.
Order portion is.
47, my
serial
lord.
number
47.
The present writ petition is filed, agreed with the orders passed in GNWC number 1 of 2016, dated 1st January 2019, whereby the court below had dismiss the petition filed by the petitioner under section 6 and 7 of the GNWC Act. The father is granted visitation rights and is entitled to meet his son in the last Sunday of every calendar month between 12 noon to 4 p.m. in the presence of presence of his mother.
Even that is also not permitted.
The respondent or anybody on their behalf should not obstruct or do anything which makes it impossible for the petitioner to exercise his visitation rights. The court, the agreed thereby, the present writ petition is filed under Article 227 of the Constitution of India. When this matter came up on the last occasion, when this court asked how a writ petition is maintainable against the said order, Land Council has sought time, and when the matter came up today, Land Council has drawn the attention of the court to the relief which he has sought, wherein in the petition he has sought to hand over the permanent custody of the minor child to the petitioner. It is submitted that Order 47, Section 47 of the GNWC Act deals with the orders which are appealable, and finding and reading at 47A, wherein it states that under Section 7, appointing or declaring or refusing to appoint or declare a guardian is an appealable order. Land Council submits that, looking at the prayer that he has sought, that do not fall under 47A, as such a writ petition is maintainable before this court under 227. Next paragraph. This court is not able to appreciate the said submission of the counsel for the petitioner, whether whatever is, however the relief is framed, ultimately an order is passed under Section 7 of the GNWC Act, which is an appealable order as per Section 47A of the Act. In that view of the matter, this writ petition is not maintainable, and the petitioner is at liberty to file to convert this writ petition into an MFA.
Gratefully, Your Lordship.
Within the conversion, the
Necessary.
same shall be done within 15 days from the date of receipt of the copy of the order. After that, the same shall not be entertained.
No, within that time. Oblige.
Yes. For statistical purposes, this petition is disposed of. Yes, next.
Cell number 5 disposed. Cell number 6. Cell number 6.
It should have not been brought placed before this court. It should have been before the registrar.
Registrar.
Hmm.
But registrar declined to do this because there was a prayer order of
No, that I have spoke to
Yes.
them. They can't keep it here. They can't place such a,
My lord,
such an.
I seek this honorable court indulgence that
It's not at this point of time, when the matter is disposed and it is placed.
My lord,
before
there
the
are
court.
other two connected matters which are being posted on 22nd. As the girl's life itself has been ruined, the matter is of, when they got married, it's 14. The divorce petition of 17, still the complete maintenance is not paid.
This writ petition was disposed of long back by this court. However, basing on a letter dated 5/6/2024, passed with the principal judge seeking a transfer of this case from one court to the other, this is placed before this court. The registry ought not to have placed the same before this court and should be on the administrative side. These issues have to be tackled. Yes.
My lord, maybe directed to send back within 27th is the matter, next hearing date. It was, this honorable court direct.
What has happened, sir?
Yes.
This is a matter, but portfolio pertaining to some other learned judge. And it is, we can't direct them saying that do it within so and so. Yes.
Cell number
Let I-
7. Sagar V. Shastri for petitioner. Sagar V. Shastri.
No representation on behalf of the petitioner. Post for dismissal tomorrow. Next.
Cell number, preliminary hearing, cell number 8. Vinay Swami C. Gautam Raghunath for petitioner.
Learn counsel for the response.
Respondent,
You have filed the memo of calculation.
that they are stay
Huh?
together. They are staying together in the sense they went to America together because their son, who had finished his BS, could not get a
MBBS.
Why are they staying together and fighting the litigation like this? Learn counts for the respondent is present, no representation.
10 days. And
Huh?
whether she has, I don't think the girl, the lady has come back from state. My client has come back.
Because we can't wait her to wait till she comes back. Post this matter, learn counts for the petition is not present. Counsel for the respondent is present. Post this matter for dismissal tomorrow.
Serial number 9. Chandranath R. Gaule for petitioner.
I appear for petitioner, my lords. The petitioner herein filed a dissolution for marriage on the ground of impotence and cruelty, my lords. So, to prove my case, I filed an application, that is IA number 5, for the direction of the Honorable Court to subject the petitioner for the medical examination. Meanwhile, my lords, at the time of mediation, the respondent made an open statement that he is traveling to abroad since he obtained a job. So we brought to the notice of this honorable court by making an application, that is IA number 6, your lordship find it on page number 36, my lords. Not to leave the country, without the permission of this honorable court. My application is not considered by the trial court, and adjournments were given without considering my application. So we are before your lordship to seeking for interim prayer to direct the respondent not to leave the country without the permission of this honorable court.
We'll direct the court below to decide it.
Our prayer is that, my lords,
That
since
only let
he-
it be. We'll not keep it pending. We'll court below to decide it. Court will decide it. Within 15 days from the date of receipt of the copy of the order. We'll not keep the writ petitions pending like that.
my lords, kindly note.
Why should this court interfere with all that? Now, when the
Well,
court
it's-
has not passed an order, we direct the court to pass an order in 15 days, but will not grant any order now. When was this this is filed? On 23/4/2024.
Please.
Now, where you are coming before this court in the month of July, and you want an interim order now.
My
We
lords,
will ask the court to dispose it off within 15 days.
I'll take instructions and I'll come before lordship.
But ultimately, there can't be any order, by whatever are your
Pass over the
instructions.
matter,
Post
ma'am.
tomorrow,
My lords, kindly pass over the matter.
pass over.
Number 10. Mani Reddy.
Petition, section 24 petition, my lord, the impugned order is at annexure A, page 13. My lords may
How much
kindly,
is the maintenance granted?
10,000. His
What is the-
salary is 10,500.
10,000?
500.
Was it considered by the court?
Please, my lords may
10,000 is granted.
my lords may kindly see at page 20, paragraph 10,
Page 20.
please.
Hmm.
Learned counsel for paragraph 10, my lord. From the mid page. Learned counsel for the petitioner has argued that earlier the petitioner was working in another company wherein he is earning that amount. Now he is even working as a storekeeper. And
Earlier, what was his income?
earlier, maybe 30,000.
Hmm.
17,000.
Anyhow,
My instructions are
Now,
17.
when is the petition filed?
Application is filed on 7/8/23, my lord.
7/8?
23.
So it's almost 11 months.
Please,
Pay 5,000.
please.
Learn counsel for the petitioner. Submits as the salary of the petition is 10,500 and the court had granted 10,000 as maintenance, and all these aspects were not considered by the court. Considering the submission of the learned counsel, they shall be stay of all further proceedings pursuant to the order dated so and so, on the condition that he shall deposit an amount of rupees 5,000 by 5th of every succeeding month, and the arrears for 11 months at 55,000 within 4 weeks from the date of receipt of the copy of the order. The petitioner shall serve the notice on the council, shall serve a personal notice on the council appearing for the respondent before the court below by 29th, and shall file a memo to that effect before this court. Post this matter. Why is it kept there? Post this matter on, I'll keep it here. Post this matter on
Trial portal ಯಾವತ್ತಿದೆ? Trial portal ಯಾವತ್ತಿದೆ?
Post this matter on 21st of July, August.
I'm grateful.
Yes.
Serial number 11. CH-23 for petitioner.
I represent the petitioner in this matter, my lord.
Yes.
My lord, the petitioner and respondent, their husband and wife. The marriage of the petitioner and respondent taken place on
What is the impugned order?
impugned order is filed under section 26, my lord. They have filed an application during the pendency of the MC petition for the interim visitation right of the child, my lord. My lord, the order passed at Annex A. My lord, while there is no pleading, my lord, in the petition of the petitioner here in the MP petition, there is no sufficient pleading regarding that. And in the objection of the respondents also, there is no sufficient
You are the
pleading
father.
I'm the mother, my lord. I'm the mother. And the
You are the
father filed the application for visitation right. My lord, without any
Station rights on all Saturdays and Sundays and also during vacation is given to the respondent
yes,
till the disposal of the petition. What is the
and
age
there
of
is
the boy?
it is 5.5 years, my lord, now. Now it is with the mother. And my lord, there is no sufficient pleading from both sides regarding that. That is one aspect, my lord. The second is, my lord, the time, my lord, your worship may kindly see in the order that in any time in the morning, the child has to be returned back at 7 p.m. That is the order. But picking time is not mentioned, my lord. The petitioner has to wait.
That we will mention, and you please take out notice on the council appearing before the court below. Once the party comes, then we will look at the other reliefs.
Please, my
Here
short
counsel
date.
will do.
Yes.
Then comes for the petitioner submits that on an application filed by the husband seeking visitation rights, the court, no, not the land council for the husband, agreed by the orders passed in I number 2, whereby the father was granted visitation rights on Saturdays and Sundays, and also during vacation. And further, the father was permitted to take the child on every Sunday at his convenient time and to bring back the child to his mother's custody within 7 p.m. of every Saturday and Sunday. The mother is before this court. Land council submits that the boy is 5.5 years old, and the court has not even mentioned the time when the boy has to be picked, and the court has failed to consider the relevant factors and particularly the age of the child, considering the submission of the land council for the petitioner. That it is made it clear that the father shall pick up the child at 11 o'clock on 11 o'clock on Saturday, 11 o'clock on Saturday, and shall bring the child back at 7 o'clock in the evening. And on a Sunday, he can take the child at 4 o'clock and get him back to the mother at 7 o'clock. But counsel for the petition is permitted to take out notice on the counsel appearing before the court below for the respondent, and shall file a memo to that effect by 19th, and post this matter on 19th, and post this matter on 20 on 30th.
Grateful, please.
Yes.
Cell number 12. Something of consideration for petitioner.
Petition by wife. Petitioner is challenging the order dated 27 to 2000.
What is the order?
Order of maintenance
How much is granted?
granted for the wife 10,000, for children 5,000, 3 children. And this order has already been stayed because the husband has challenged it another petition.
What is the connected number? Please give that.
WP 11736. I will
Write on a paper and give.
kindly
Post
correct
along with it on Tuesday. No, it can be posted on Wednesday. How many matters are coming on Wednesday? I mean, holiday, Thursday? How many matters are coming? Thursday.
Much okay.
Yes, next.
Cell number 13, adjourned. Cell number 14. Babu TC for petitioner.
For the petitioner, my lords. In this, my lords, I am the husband. And the respondent has filed an IA application under section.
How much is granted?
15,000, my lords.
What is the income of the husband?
It varies, my lords. It's for 56,000 and it varies every month since he works on a contractual basis, and the same has been recorded in the order sheet, my lords.
So what is the maximum amount you would get in a month?
54,000, my lords.
Minimum?
Maximum is, no, maximum it as per the, he has produced the salary slip of May, June and July, and it has been 70,000 aggregate. But a minimum he gets is 54,000, my lords. It varies since.
So what is the difficulty in paying 15,000 to wife?
The father of my father is a cancer patient, my lords. We have to make medical.
10,000.
allowances.
When is the petition?
The petition was filed on 25/11 of 2022.
25/11 of
2022, my
That
lords.
is 12 months.
And it was ordered on
It is,
3/6 of
8
24,
months.
my lords.
12 plus 8, 20. Now it is 20 months
Yes, my lord.
due.
Due is, we have, it was ordered on 3/6 of 24.
No, that's not the relevant from the date of petition.
The due we haven't paid yet, my lords. We haven't paid yet.
So from 20 months,
Yeah.
if it is 2,000, 10,000, you have to pay 2 lakhs.
My lord, we.
Arrears.
Arrears, yes, my lord.
And continue to pay 10,000. Land counsel for the petitioner submits that the court below without considering the fact that the father of the petitioner is suffering with cancer and he has been taking care of his treatment and which requires substantial amount, has granted an amount of rupees 15,000 to the wife. By considering the submission of the land council, they shall be stay of all further proceedings pursuant to so and so on the condition that the petitioner shall continue to pay an amount of rupees 10,000 by 5th of every succeeding month. Then the arrears for a period of 20 months at 10,000 comes to 2 lakhs, and that shall be paid within 4 weeks from the date of receipt of the copy of the order. Either the 5,000 is not paid or the 10,000 is not deposited, that the 2 lakh amount is not deposited, the stay stands vacated without further reference to the court. The petitioner shall take out notice on the counsel appearing before the court below and shall file a memo to that effect by 29th of July. Post this matter on 21st of August.
Till 15 part-time matters, Mahesh Arukin for petitioner, TV Gunjal.
Where is he?
But one calculation I have made, Lord, kindly see.
Have you served it on him?
Lord, I have served copy.
Please take that.
Lord, total, Lord, measurement of the properties, Lord, 1,750 square feet. Out of that, Lord, what was sold to me is 640 square feet, but actually is, Lord, 576. Actually, as per document, it is 640, Lord. Actually, it's 576. Out of the total extent, Lord, D2 D1 was entitled to 25%. Other parties were entitled to 75%.
25% comes to?
25% comes to 437.5 square feet. 437.5 square feet. What was sold to me, as I submitted earlier, 576. Actually, is 576.
No, that's what I wanted. 576 and his is 30. How much square feet?
1,000.
No. For the respondent.
For the respondent, the remaining entire extent was sold to him. This 437.5 remaining extent was sold to that D9. That is the problem.
So out of 1,750, 437 is to you.
My
576 is to you.
Yes.
And remaining is to him.
To him. That is the problem.
So as for that, he is holding a major extent.
Major extent, as per the sale deed, but it appears, it was during purchased during pendency of the suit to defeat the rights of the parties, according to my instructions. Because of that reason, that sale deed was not acted
So what is now agreed upon?
Now, one submission, now, out of 576 that was sold to me, I am entitled to only 437.5. I have to leave remaining portion to that 75% shareholders, remaining plaintiff and defendants. Now 437.5 is not possible to divide. I am ready to pay some amount, my lord, though it is legally, I am not liable. On the other hand, I am legally liable to surrender the nearly 200 square feet to other plaintiffs and defendants who are getting 75% shares.
No. No, out of 1750
Yes,
yards, your vendor has 437.5.
437, but what was sold to me is 576 square.
That is true. Why should you give this 437 to the other plaintiffs?
No, not 437.
437 you are entitled.
Out of 576, I have to give up remaining portion, excluding
Now,
this court.
now the issue is,
Yes.
there can't be any order on the merits.
But
It is
that's
only
it.
like,
That's the
both
reason
of you
why
have to
my-
settle that issue.
My party wants, I
What
advise
he
it.
says, have you spoken to him?
He wants division of the properties in equal proportion. 437, he wants to division half of. That is impossible. It is not possible to enjoy. It's a residential premises. Totally.
There's a building in it.
Old building is there. If you touch that building, it will fall down. That's the problem. What my party says
Let
is
him
that.
come, shall we
Yes.
pass over?
Yes,
Please
Lord,
tell him, please tell him what it is, then we
Yes.
will hear once he comes.
70,000 she has purchased. My party is ready to pay 70,000 with 6% interest up to date. 34 years interest, my
So how
party.
much it comes to?
It comes to around 2 lakhs.
Now, can you get the land for 2 lakhs there for the 200 square
Lord,
feet?
but she is a Lord, your lordship may kindly see Lord
No,
conduct.
what will happen is neither of you will get it. It goes on because the court cannot decide it. Because both of you have kept quiet without questioning this, this order and the order of the review or something
Lord,
you should have clarified.
Lord, if we interpret the Supreme Court's order, Lord, it comes in my favor, Lord.
Please tell him, we will see in the afternoon. Yes, pass over.
16. Manivandan G, Dhananjaya GN, petitioner.
My lord, my senior is not feeling well, but I will make some submissions. I will make some submissions, my lord. I am very new to profession. That's my lord.
Yes.
My lord, respondent is have a government job. She is serving in KC General Hospital, and she.
Will please come to the impugned order. Then we will go on the, or you can make your submissions.
Yes, ma'am.
Where is the impugned order?
My lord.
That
order is
Petition number 14. How much is the amount granted?
4,000 rupees for each child, and also 50% of the educational expense. My
4,000.
lord. Yes, my lord.
How many children?
Two female.
So
kids.
8,000 is granted.
Yes, my lord.
And the
50% of the educational expense.
50% of the educational
Yes.
expenses from 2016 during pandemic.
Yes, my lord. This is,
Are you
here is
so
100 week,
intermittent?
100 months.
Also, you will further interim maintenance on or 10th of every month. So
Right.
please come to the order. Let's see the order. What is your salary?
So nearly 70,000 respondent is drawing, and also she having the quarters in the same premises.
This false submission, there is no any documentation.
You are the petitioner.
Yes.
I'm asking what is your salary?
He is a practicing advocate. He is practicing from home only. You don't have car and you don't have any earnings.
You having a car, you have a good office.
No, no,
He is stating
please.
in their affidavit. I will show that.
If you have anything, please submit the documents, because that they are submitting the false statement.
The annex.
And also he is suffering from the diabetics and some other disease. You have only 30-40 vacant site gifted from his father.
Madam, one partition suit is pending. As per
Yes, my
that
lord.
partition, I would like to submit. As per that partition suit, he is having a rent, collected the rent also. Father is no more. Appellant father is no more. He is the having a entire thing, a rent and earning the money.
No rent.
Practicing, well practicing
Let him
advocate.
submit, then you can. Yes.
Well practicing advocate, my lord. There is no any order clearly in that order, improved order also discussed about the practicing advocate and also as well as respondent work, my lord. She is a nurse. She is is having with two children in the quarters, my lord. She is also liable to pay the rent. So since from that day to till today, as per the that order which is placed by the appellant, more than 3 lakhs not yet paid. So due is there 17 lakhs above. The two daughters has spent by the respondent for the school education expenses and as well as maintenance, my lord. They didn't pay. In execution petition is also pending. The execution petition since from 2019, my lord, kindly refer the order sheet, my lord, which is placed by the appellant. The arrest warrant also issued, but never appeared before the trial court. So he is well aware the escape from these are all things, because they saying that he is the practicing advocate.
Yes.
My lord, respondent have the very good financial
Having
status.
she is having a job.
Yes, yes, my lord.
Didn't ask for her maintenance.
Yes.
Court has not granted.
No, madam, no, my
It
lord.
has not
And
granted.
is granted for the kids, ma'am, my lord.
You don't have any
No,
responsibility.
already paid 2,75,000 rupees.
Whatever it is you're
Yes,
paid,
my lord.
court has granted only
And also-
4,000.
Yes, my lord.
Which is a very, very meager amount. Had they filed a petition for enhancement, would have granted it.
During the COVID pendency, you don't have any work, and this one, my lord, last 3 years, he's suffering from the lot of health issues, and also he lost his father. So you don't have any other incomes, as learned.
To maintain your children, you have to maintain.
Yes, my lord. Yes,
The
my
court
lord.
has not asked you to pay 100% education.
Yes, my
expenses.
lord. And also there was some disputes between the bill, my lord. For example, silk saree of 25,000 rupees and 3,500 rupees as a slipper like that. So that's why
Only education expenses.
yes, my lord. The court is ordered only educational expense, but they are claiming all these bills and everything.
Why should you pay?
School shoes, uniforms.
No, school
Yes, ma'am.
expenses, the court said.
Yes, my lord.
Expenses only.
Yes,
you need
my
to
lord.
pay. If they are saying some other things, say that it's beyond the order of the court and you will not pay.
His earning is very less, my lord. That's
But you have to take care of the kids.
Yes,
The
my lord.
court has only said 50%. There is nothing
Yes,
wrong.
my lord.
Please come. Agreed with orders passed in I number 2 in MC number 807 of 2016, dated 11/10/2017. The husband is before this court. Parties are referred to as wife and husband for the sake of convenience. The wife had filed an IA. Who filed MC?
Section 9 petition, my lord.
F wife had filed a petition under section 9 seeking restitution of conjugal rights. In that she has filed I number 2 seeking maintenance of rupees 15,000 to herself and rupees 5,000 each per month for the maintenance of the two female children, and also to pay litigation expenses of 30,000 and arrears of school fee and educational fee of rupees 2,37,833. It is the case that the husband is earning more than 1 lakh per month and also having income from other sources. It is a case of the husband that he is a practicing advocate. And he is not in a position to pay the maintenance as sought by the wife. According to him, the wife is working at KC General Hospital, Malleshwaram, drawing salary of rupees 50,000 per month. She is able to maintain herself and also two children without any difficulty. Further, she need not pay rent. She has been allotted quarters and she is residing along with the two children. She vacated the house set up by him. She also owns other properties. And she's getting an income of 4 lakhs per annum. She owns 2 sites and house in the same village. As such, she is capable of maintaining herself and the two children.
In respect to that, one suit is pending Tumkur, my lord, in their families.
Well, right. He is also He's earning only rupees 15,000 per month out of his profession, and he has to maintain his aged parents who are suffering from diabetes and other ailments. The court below had considered all these issues. That though it is stated that he's earning 15,000, nothing has been produced to that effect. And considering his profession, the court had granted 4,000 each to both the children, and educational expenses to be paid. 50% of the expenses to be paid by the father
Educational
for
expenses.
the period from 2016. And also arrears of maintenance within 2 months from the date of the order, and also pay the future maintenance by say 10th of every month. Land counsel appearing for the petitioner submits that he's an advocate, and during the pandemic, he was not having any income. And further, it is submitted that the wife is earning sufficiently and is also having landed properties. These aspects were not considered by the court below, and it's very difficult for the petitioner to pay pay the amount as directed by the court. Land counsel appearing for the respondent wife submits that the husband is having the landed properties, and in that regard, he filed a suit for partition.
Yes.
And the same is pending consideration.
The every rent collected by the appellant, madam. Rent as collected by
No,
the.
no, my
appellant.
lad. There is no rent, there is no
This is the
property.
matter is pending before the civil court, my lord, for the partition. In that suit, properties, the rented properties is there. He has collected the rent.
It is stated that in the said suit, during the pendency of the suit, the rent was ordered to be paid to the petitioner, and he has been enjoying the same, having the petitioner.
My lad, one small sum. Rent is going to her mother, his mother, my lad, not for the.
They are all.
If they have
living
any
with-
proofs, kindly submit it. Yes, my lad. Yes, my lad.
Your father is no more.
No.
No more, my lad.
What did you write? Before that, land counsel for the respondent had land counsel the petitioner had denied the same, and submits that as his father, her father is no more. The same is the rent is now going to the mother, and he do not have any, he do not, and still is left with no money to maintain the children and to pay the educational expenses. Having heard the counsels on either side, produce the material on record. The court below had granted an amount of rupees 4,000 each, that is 8,000 to both the children, and no maintenance is granted to the wife. As such, the contention of the husband that wife is earning, she is not entitled for maintenance, need not be considered by this court. Then coming to the maintenance of the children, just because the wife is earning, the husband cannot say that he will not maintain the children. The court has granted only a meager amount of 4,000 and 4,000 to both the children, and also only 50% of the educational expenses. Being the father, he has to take care of the children as well as the mother. The educational, even the educational expenses also 50% were only directed to be paid by the husband. If it is a case of the husband, you would have filed all the details before the court to show that this is what he is earning, but unfortunately, no such evidence is placed before the court, and court has also had observed the same in the order. Considering all these aspects, this court finds no reasons to interfere. Accordingly, the petition is dismissed. Yes.
My lord, small. We are ready to pay 1 lakh, and also every month we are paying the next month onwards, my lord. India allow this.
What is that?
In the balance amount, 1 lakh, we are ready to pay within 2 weeks, my lord. And also next month onwards, we are paying regularly. India allow the entry month.
17 lakhs above, except this year.
Only 8 lakhs, my lord, because
education
100 months. 100 months. So that means 8,000 means 8 lakh rupees, madam.
The execution
Among that
code
2 lakh
issued the
75,000 already
arrest
paid.
warrant, my lord. They didn't appear single day before this court, my lord.
In the
They-
contentions of the land counsel for the respondent, you record, right? That land counsel for the respondent submits that the execution petition is pending, And at any point of, in spite of the warrant, even till now, the petition has not appeared before the court. And the said order could not be executed. Yes.
Much obliged.
This for interrupting, my lords. With respect to serial number 9, my lords, I obtained the instructions. Kindly dispose it of as suggested, my lords.
Serial number 9.
9.
WP 15057 of 2024. The present writ petition is filed seeking the prayer to the court below. Seeking a direction to the court below to consider I number 6 dated 23/4/2014, whereby an application is filed directing the husband not to leave the country without the permission of the court, and also
I number 4.
sought an interim prayer from this court seeking a direction to the husband not to leave the country till the disposal of the application. This court is not inclined to pass any interim order in this case. This IA is filed. When is IA filed?
24. 23/4/2024.
23/4/2024.
2024.
The application is filed on 23/4/2024 with the apprehension that the respondent is leaving the country. When such an application is filed, the court ought to have considered the same, considering the urgency as stated by the petitioner. Considering the same, the court deems it appropriate to direct the court below to dispose of the pending IA number 6 as expeditiously as possible, but not later than 15 days. The 15 days, this court is not proposing to issue notice to the respondent as disposing of an application is in the interest of both the parties. Yes, next.
Obliged.
Bill number 17, Rajiva BC for petitioner. Giridhar, this week.
Lords, I appear for the petitioner.
To appear for petitioner.
One is filed by?
The first petition, my lord, that is WP 2085 of 2016 is filed by me, my lord, that the plaintiff is a suit for partition, my lord. In the examination chief.
What is IA in this? Your writ petition?
IA number 5, my lord.
What is IA number 5?
IA number 5 is, my lord, Order 6 Rule 17 application filed by the present respondent for amending the written statement. That has been allowed, my lord, in the first case.
Second?
In the second case also, my lord, that is in respect of IA number 11 in the same suit filed by the respondent only for one more application for amendment. Even that application also, my lord, on the similar lines. Therefore, my lord, trial court dismissed that application. Against that, my lord, he has challenged that order.
So first, let us look at your writ petition.
Please, my lord.
Where is the impugned order?
Impugned order, my lord, kindly turn to, my lord, page 46, man. Before that, my lord, may state a few facts, my lord. My lord, in this case, my lord, on 10/10/14, my lord, my examination chief was over.
10/10?
10/10/14.
10/10. Suit is of the year?
2012, my lord.
2012.
12.
And your examination chief was completed?
10/10/14. Then, my lord, it was posted on, my lord, 23/2/15. For cross-examination of PW1. On that day, my lord, he did not cross-exam. Therefore, my lord, on cost of rupees 200, my lord, it was adjourned.
Adjourned to?
Adjourned to 15/4/15. On that day also, my lord, I didn't correct exam me. Therefore, on further cost, my lord, it was urgent to 14,750.
Yes.
On that day, my lord, he has filed this application. IA number 5 has been filed.
Now let us see.
Please,
What is this application? Page number?
Annexure C, page number 22, my lords.
To add following paragraphs, additional paragraphs 11A to 11E. The plaintiff at an earlier occasion has filed a suit for partition and separate possession of their alleged share in the alleged joint family properties possessed by the said family in OS number 431 2010 on the file of the Honorable 4th Additional Senior Civil Judge at Mysore in para number 4 of the plaint of the said suit. It is alleged that the bearing survey number 148 is acquired by Muda, Mysore, and compensation amount have been received by her father and brothers. It is also alleged that the other members of the joint family have sold their sites allotted to them as the land losers. There's no relief is sought for against the said land, that is the land bearing survey number
Who is this
148.
defendant?
Please, madam.
Who is this defendant?
He is the present respondent in my case, madam. He is defendant number 13.
Who is he?
Madam, he is the purchaser, madam. Purchaser from my father and brothers.
What is the suit OS number 431 of 2010?
That is also partition suit, madam.
In that,
But this property was not, my lord, I was not aware of the existence of this property. Therefore, my lord, I filed
no, but in that suit, that is what he's saying now.
please, ma'am.
That in that suit, there is a mention about this property. That the plaintiff at an earlier occasion so and so, it is alleged that land bearing number so and so is acquired.
Please, ma'am.
So whatever is the subject matter of this suit, now why you have made him a defendant, there is a mention about the joint family property which was sold, and there you didn't raise all the issues.
No. But in the present plaint, my lord, I have raised all the issues. In spite of it, my lord, he has not chosen to complete a written statement. At the after my lord, commencement of the evidence, he has to drag on the proceedings, my lord, he has filed this application. Like now, kindly see, my lord, reasoning given by the trial court.
No, as far as this is concerned.
Please, ma'am.
This is nothing is disputed. These are all admitted facts. It's not a new case.
But please, now kindly see the reasoning given by the court below.
We'll go to that.
Please, ma'am.
No, is it a very new case that is set up with him? It's an admitted fact that you filed an earlier suit. In the earlier suit, you have not stated anything with regard to that.
But in the plaint itself, my lord, I have disclosed all these things. He had an opportunity to file the detailed written statement at the earliest point of time. My lord, only to drag on the proceedings, my lord, after matter posted the cross-examination, adjourned for about 2-3 times. After that, my lord, is a well thought of.
Ultimately, the same thing has happened now. Ultimately, 16 writ petition, we are hearing it is 24. 8 years have passed by. Have you accepted for this by this time?
No.
Suit for partition would have been disposed of.
I will come to next written.
Now let us go to the order.
May I just clarify, my lords?
The reasons, my lord. The reasons, my lord. This is a suit. I will read from the suit reasonings, my lord. Page 46. Your lordship got it, ma'am. Reasons, my lord. This is a suit filed by the plaintiff against the defendants for partition. In the amendment application, the defendant number 9 wants to plead that there was an earlier suit, OS number 431 of 2010, filed before the 4th Additional Senior Civil Judge Mysore. Therefore, the second suit for the partition is not maintainable. The objection of the plaintiff that there was a delay in filing the application, and the application filed by the defendant number 9 after the commencement of the trial is not maintainable. On perusal of the records, it is seen that the defendants have not cross-examined PW1,
The proposed amendment is necessary for the purpose of just decision in the case, as the second suit for partition is not maintainable, though the application for amendment cannot be allowed for the commencement of the trial after commencement of the trial. There is no absolute bar for allowing the amendment application if the court come to conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of the trial. The defendant number 9 in her affidavit has stated that there was not that she was not aware of the previous proceedings, and only after the plaintiff filing the plaint written statement and other documents relating to the said suit, she came to know about the same. As contended by the defendant number 9, the plaintiff has not pleaded anything about the previous suit for the partition in the plaint, and only at the time of trial has produced the documents relating to this suit. Therefore, this court is of the opinion that the defendant number 9 has proved that in spite of due diligence, she could not take up the said plea. That this is the reasoning, my lord. Now kindly turn to my lord in the plaint. I have stated about these facts, my lord, in my plaint. Kindly turn to page
No, the issue is.
10, my lord.
You have stated about the same in your.
Plaint I have stated.
plaint. No. What is their case is, they could find about the earlier suit and your stand now. No, ultimately, it is for the court. Court has given a reasoned order, but it is necessary.
But the reasoning given by the court is that in spite of my lord exercising due diligence by the defendant number 4, he could not take up this plea in the written statement filed by him.
But this is a case where it goes to the root of the matter, and even it is necessary for the court to adjudicate the same. So court
But
rightly
that
allowed-
reasoning, my lord, that reasoning given by the court, that in spite of exercising due diligence, he could not have filed the written statement.
He doesn't
may
know
not
about
be,
it,
it
because
may
he's
not
not a
be.
party in the earlier suit. That's why the court said due
My lord,
diligence.
my lord, all these things, my lord, I have stated in para number 5 of my plaint, my lord.
You have stated in your plaint.
Please, ma'am.
He will know about it necessarily if he knows about the earlier suit. What is the stand taken by you in the earlier suit? Unless
Please,
until they come across, they don't know. So please come to the next case.
The next case, my lord. My lord, kindly turn to my lord, para 20, page 23.
Of
Annexure C.
Next case.
Next case. Ma'am. Even there also, my lord, on the same lines, my lord, he has filed this application. When the matter was posted for defendant evidence,
23.
Annexure C, my lord.
23.
Your lordship got it, my lord. Kindly see, my lord, amendment sought for. On the same lines, my lord, this application is also filed by him.
Yes.
Now, my lord, come to impugned order, my lord.
No, we will ask him. I understood what.
Impugned order, my lord, kindly see, my lord.
Yes.
Though there was a stay order in my first writ petition, after that, my lord, which was not extended for time. At that point of time, my lord, amendment has been carried out to the written statement, and trial court directed him to proceed with the matter. And when after my cross-examination, when the matter was posted for defendant evidence, at that point of time, my lord, it makes a similar application has been filed by him. Come to page 34, my lord.
30?
Page 34. In page 34, man.
Yes.
Your lordship got it, man.
Yes.
Para 8, my lord. May I read from para 8, man?
Yes.
Earlier, the 9th defendant has filed IA number 5 under Order Circle 17 for amendment of the writ petition. After hearing both the parties, the said IA came to be allowed. But before amendment was carried out, the plaintiff have referred writ petition number so and so on the file of the Honorable High Court of Karnataka, and the said petition is pending for adjudication. Initially, there was an order of stay in favor of the plaintiff. Thereafter, the stay has not been extended. As the suit is more than 80 years old, the order of stay has not been extended. My predecessor in office has advised the parties to proceed with the matter. In the meantime, the 9th defendant has filed instant IA. Herein, it is relevant to mention that even though order of stay has not extended, in the aforesaid stated writ petition, the 9th defendant did not take any trouble to seek the permission of the court to carry out the amendment to his written statement as per order passed by earlier. Then, he filed IA number 12 invoking section 151 of CPC, seeking permission of the permission to carry out amendment as per earlier order. After hearing both the parties, said IA came to be allowed and the written statement has been amended as per earlier order. This is the suit of the 2012, and already an opportunity was given to the 9th defendant to carry out amendment in his written statement. But at the fag end of the proceedings, once
I've
again
seen
he
the order.
filed
I have
the
seen
instant.
the order.
Please.
Yes. Yes, what do you say?
Madam, may I submit one ruling, my lord, that Supreme Court order. That is, my lord, under what circumstances, my lord, that amendment to the pleadings can be permitted. But certain guidelines, my lord, have been envisaged by the Supreme
Pass on,
Court.
pass on.
Please, though it is not exhaustive, but inclusive examples have been given by the Supreme Court. That, para 20, my lord. Para 20 may come to para 20, my lord, is para 20, my lord, is the full bench judgment, my lord.
Yes.
On critically analyzing both the English and Indian, some of the basic principles emerge, which ought to be taken into consideration while rejecting the application for amendment. Whether the amendment sought is imperative for the proper and effective adjudication of the case. Whether the application for amendment is bona fide or mala fide. The amendment should not cause such prejudice to the other side, which cannot be compensated adequately in terms of the money. Refusing amendment would in fact lead to injustice or lead to the multiple litigation. Whether the proposed amendment constitutionally or fundamentally changes the nature of the character of the case, and as general rule, the court should decline amendment if a fresh suit on the amendment claims to be barred by limitation on the date of application. There are some of the important factors which may be kept in mind while dealing with an application filed under Article 17. These are only illustrative, not exhaustive.
Your case fall under,
Bona fide, man.
your case fall under one.
One man. But
Whether
that's
the
my lord,
amendment
but
sought
his,
is temporary.
his application, my lord, falls under, my lord, that's a second, my lord.
This
Bona
is-
fide or mala fide?
This is the next petition.
Please.
Yes, what do you say?
My lords, may I request this court to kindly take page 10, paragraph 5 of the.
No, how many times you will seek amendment of your pleadings? Whenever you remember, whenever you want to.
I'll go by writ petition, my lords. Initially, when the suit came to be filed, I was not aware that there is any prior suit for partition. It was not revealed in the plaint.
For that, you have filed an amendment once.
My lords, I'll clarify, my lords. For the first time, when the examination in chief was carried out, they produced the certified copy of the plaint in the previous proceedings. When I came to know that there was such a suit, the suit number was not revealed in the plaint which was initially filed by them. So I preferred the first application for amendment. First application for amendment came to be allowed, specifically holding that I could not have known the case number unless it was revealed. The certified copy of the plaint was produced only for the first time, the examination in chief. That is the reason why we had to move. Now, my lords, that application for amendment specifically contained a plea based on the contents of the plaint and order sheet of the proceedings in the previous suit. That is all. I said that from what is produced, this is what has come to our notice. My lords, in the proceedings which were initially filed, that plaint of the earlier suit, on verification, I came to know, my lords, that it was not revealed in the present suit. In the previous suit, it was stated that the land is notified for acquisition.
No, as far as the first matter is concerned, you don't have to make any submissions, sir. Court is in favor of you.
So
Then
for
what
the-
about the second case? The court
So
is
as
going
the
to-
second case is concerned, when I got the records pertaining to the earlier suit, on verification, I came to know that this land is notified for acquisition. I went to the Mysore Urban Development Authority, took out the records pertaining to the acquisition, and those details relating to the acquisition is the subject matter of the second petition. May I request this court to kindly take annexure C, page 23 in the second writ petition?
No, you came to know your value when you have filed the first petition for.
Because I only came to know that there was a previous suit. I never knew that there was an
You
acquisition.
came to know, then from there on, you keep on like, and you do every step what you come to know, you can't file
My
applications
lord,
like that.
these records were part of a government authority, my lords. The land that is notified is known to the parties. Therefore, may I request this court to kindly take annexure C, page 23 in the second petition.
Yes,
This is what I want to incorporate.
yes.
It submitted that survey number 148 totally measures 13 acres, in which 7 acres 10 guntas is acquired by Mysore Urban Development Authority, Mysore, for formation of a layout. The remaining extent of 5 acres 12 guntas is available. In that 4 acres 22 guntas has been sold by this defendant's predecessor and registered sale deed by executing GPA in favor of this defendant. In respect of survey number 148 measuring 1 acre 20 guntas, remaining land to be executed registered sale deed by Papa and others to this defendant dated 5/7/2007. As such, this defendant has become the owner in possession of 4 acre 22 guntas, and the remaining 32 guntas is in the possession of the owners even today. It is stated that from all these documents produced by defendant, as the remaining 32 guntas is in custody and possession of the predecessor of the plaintiff for acquisition of 7 acres 10 guntas in survey number 148. Some of the defendants here and the predecessor have received the compensation amount, including land losers from Muda, Mysore. Hence, the suit does not survive by non-impleading of proper and necessary parties. My lords, they have taken the compensation. They have taken alternate sites in lieu of the compensation. That extent of land and that alternate sites were not added in the suit for partition. This records I could get only from the records of the Urban Development Authority. I only came to know that there is an acquisition and that there is a previous suit. When I got the details relating to the acquisition, I verified the records, I secured it. And all of this, my lords, would be necessary, specifically in view of the fact that this is suit for partition. The entire estate has to be made available. The manner in which the estate has devolved has been dealt upon by the predecessors of the plaintiffs also has to be stated. My lords, even without stating it, I could have produced the details relating to acquisition and got them marked as exhibits, which should be public documents. Therefore, my lords, there is no prejudice which has caused the respondents
Yes.
in my writ petition. The writ petitions, my writ petition may be allowed and the other writ petition may be
Yes.
kindly dismissed.
WP 2085/2016. The present writ petition is filed, agreed with the order passed in. IA number 5 and OS number 23 of and OS number 23 of 2012 dated 26/11 dated 3/12/2015 by so and so. The present writ petition is filed. The petitioner before this court is the plaintiff in the suit. He has filed the suit for seeking partition and separate possession of the suit scheduled properties. The defendant number 9, who is a purchaser, has come up with this IA number 5, seeking amendment of the written statement. And by way of this written statement, he wanted to add para number he wanted to add paragraph number 11A to E at the end of para number 11. And by this, he wants to state that the plaintiff herein has earlier filed OS number 431 of 2020 on the file of the 5th additional senior civil judge at Mysore. In para 4 of the plaintiff in the said suit, it is stated that land bearing survey number 148 is acquired by Muda, Mysore, and compensation amount have been received by her father and brothers. It is also alleged that the other members of the joint family have sold the sites allotted to them as land losers. No relief sought for against the said land, that is land bearing survey number 148. It was well within the knowledge of the plaintiff at the time of filing of the suit. that an extent of 4 acres 22 guntas, which is a subject matter of the present suit, is already sold by the father and brothers under the registered sale deed dated 4/1/2007 and 5/7/2007. In spite of that, they have sought for a relief in this writ petition, in the present suit. And according to him, a second suit for partition is not maintainable. It is a case of the defendant that they have, at the time of examination of PW1, they have filed the copies of the plaint, judgment and decree invoice number 431 of 2010 on the file of the fourth additional senior civil judge at Mysore. At that point of time, he has come to know about all these facts, which necessitated him to come up with this application. It is submitted that, and that the said application may be allowed. The respondent plaintiff had has filed his objections, stating that the said application cannot be entertained as it is filed when the matter is posted for the cross-examination of PW1. Then by order impugned, the court below, the trial court had allowed the application, observing that till the examination in chief of PW1, they're not aware of the earlier suit. And they could not take up they could not take up such a plea. Considering all this, the court has felt that in spite of their due diligence, he could not place this, he could not read these facts before the court. And no prejudice would be caused to the plaintiff by allowing this application, as these applications, the same as raised by the plaintiff in the other suit, and accordingly allowed the petition. Learned counsel appearing for the petitioner submits that the suit is of the year 2012. And on 10/10/2014, the examination in chief of the plaintiff has been done. On 23/5/2015, the matter is posted for cross-examination of PW1, and the same was not done on that day. And the court has adjourned the same at cost of 200 and directed them and posted to 15/4/2015 for the cross-examination. Even on that day also, it was not cross-examined, and again the court has imposed further costs. Then the matter came up on 14/7/2015. On that day, they have come up with this application. It is submitted by the learned counsel that the court below had in giving an observation there is due diligence. When all these facts were narrated by him in the plaint itself, question of due diligence will not arise, as these facts were very much known to him as on the date of the filing of the suit, but the filing of the written statement, and no grounds are made out for amendment of the written statement. And the court below ought not to have allowed the said application. He had relied on the judgment of the Honorable Apex Court in case of Ram Niranjan Kazaria versus Shio Prakash Kazaria and others, reported in 2015 10 SCC 203, wherein the court had considered the earlier judgments in case of Ravazitu Builders and Developers versus Narayana Swamy and Sons, that is 2009 10 SCC 84, wherein the court, wherein certain guidelines were issued, where an amendment of pleadings can be allowed. In this judgment, para 20, in that there is para 63. The 63 you extract. Relying on that, the then counsel submits that the court below ought not to have allowed the amendment and the IA that is filed by the defendant. Next one, learned counsel appearing for the defendant submits that they have, in the suit that is filed, they have not mentioned about in the plaint, they have not mentioned about the suit number of the earlier suit. And now when during the chief examination, when all those documents are placed, then he has come to know about these facts. And as such, he has come up with this petition. He submits that these documents do not, if these documents are marked, it would not cause prejudice to the plaintiff. And it is submitted that it is very much necessary for effective adjudication of the case. And he has also, the due diligence factor has also appeared and which has been appreciated by the court. Next, having heard the counsels on either side, there is a material on record. In a suit of 2012, in the year 2015, an application is filed seeking amendment of the pleadings. The whole basis for filing such an application is that, with regard to the earlier suit and other things, he has come to know on the day when the chief examination affidavit is filed, and along with that, these documents are also filed. Till such time, he is not aware of the suit, which has to be considered as this defendant number 9 is not a party to the earlier suit. And the information and the pleading that is now sought to be placed on record by the defendant is also very much necessary for adjudication of the dispute between the parties in a very effective manner. And this court is of the view that as far as the due diligence is concerned, considering the pleadings, the court below had rightly gave a finding, and this court finds no reasons to interfere. Just because this application is filed at the fag end of the trial, once the trial has commenced, that itself is not a ground for the court to dismiss the application. And the court below had rightly considered and allowed the IA seeking the amendment of pleadings. And this court finds no reasons to interfere. Accordingly, the writ petition is liable to be dismissed and stands dismissed. Next matter. WP number 6766 of 2021. The present writ petition is filed, agreed by the IA agreed by the orders passed in IA number 11, dated 25/2/2017. Yes, Mr. Counsel.
My lord, sir, 22nd of March 2021.
Page number?
Lord, 2nd of March 2021. my lord. At page number 32, annexure.
December 12th, 2015.
No, my lord, 2nd March 2020.
2nd March 2021, madam.
Annex,
Page number?
32, Annex E.
page 32.
Page 32. Dated 2nd March 2021, whereby the court had dismissed the application for dismiss IA filed by the defendant under Order 6, Rule 17, that is Section 151 CPC. The suit is filed by the plaintiff seeking the partition, and in that DW9, the defendant number 9 is the purchaser of the property, of the joint family property. Earlier, he had filed IA number 5, stating that once the defendant plaintiff has filed the chief affidavit, and in that the documents and the suit numbers are stated, then he has come to know about the earlier litigation, and he has come up with an IA number 5 under Order 6, Rule 17, and the same came to be allowed by the court. Against that, a writ petition is filed before the court. Thereafter, this application came to be filed on 27/11. Is it 27? Date of the application?
But the date of the application is not known, my lord, so. It just
No,
registered
the
with IA number
objections to
11.
that are filed on 27/11/2020. That is somewhere in the month of November, you must have filed.
Yes,
Then
ma'am.
thereafter, after 4 months, after 3 months, after 4 months from the date of the earlier application, they have come up with another application whereby he wanted to amend the pleadings by inserting
Paragraph number 11E. my lord.
paragraph number 11E, whereby he wanted to bring to the notice of the, and with regard to the properties, and also the suit is bad for non-joinder of proper and necessary parties.
The details of acquisition were sought to be produced.
It is stated that the same reason is also stated in this case, that earlier there was no whisper about all these things in the plaint. As such, he has come up with this application. And the court below application. The court had considered this, and court felt that only to drag on the proceedings, and there should be an end to the litigation, and these kind of application, one after the other, cannot be entertained, and dismiss the petition. When counsel appearing for the petitioner, defendant number 9, submits that the court below ought to have considered the same, as the suit is bad for non-joinder of proper and necessary parties. And unless and until there's a amendment is allowed, there cannot be proper adjudication of the dispute between the parties. The court below erred in dismissing the application, and the petition is liable to be allowed. Learned counsel appearing for the respondent submits that the defendant has been protracting the litigation on one pretext or the other on several occasions. The suits have been on several occasions. He has failed to cross-examine the PW1. Earlier application was filed on 14/7/2015. Now, again, another application is filed, and it is nothing but a pure abuse of process of law. And the court had rightly dismissed the petition, and no grounds are made out seeking, no grounds are made out to interfere with the well-considered order passed by the court. Having heard the counsels on either side, there is the material on record. The earlier IA that is filed under Order 6/17 is already allowed by the court. Now, for the very same reason on which they came to know, that is the plaintiff filing the earlier, the details of earlier suit. Now, in continuation of this amendment is filed. The court cannot keep on allowing the applications on the same knowledge and notice of a fact whenever the defendant comes before the court. The court below, the petitioner ought to have filed such an application along with should have taken all these reliefs along with the earlier IA number 5 that is filed. And he has waited another 3-4 months to come up with this application. Even the conduct of the defendant earlier, where on several occasions he failed to cross-examine PW1, also shows that with an intention to delay the proceedings. These kind of applications are filed, and this court finds no reasons to interfere with the well-considered order passed by the court below. Accordingly, the petition is dismissed.
Grateful.
Yes, next.
Lordship's kindly, my lord, direction may kindly be issued to the trial court, my lord, to
This
close
suit,
as early as possible, ma'am.
this is a suit of 2012, and the court below shall dispose of the same as expeditiously as possible, but not later than 6 months. Yes, next.
Cell number 18, Ramesh NJ, PH Virupaksheya for petitioner, Vaira Reddy G.
I am appeared for the petitioner.
Hmm.
Suit for declaration and position.
Declaration and possession.
Position.
You are the plaintiff.
Trial court in the, I am appeared for the
Defendant.
defendant. A suit filed by the petitioner seeking
Declaration and
information
possession.
here, position.
Hmm.
The
What is the IA
state-
fine?
IA not filed, the trial court has import the stamp duty and penalty.
Hmm.
And sum of rupee 25,000.
Tell the page number, I will look at that order. Please come to that order.
Please come to page number. Come to please page number. ST1, my lord.
Why you have filed a counterclaim in that?
Yeah, please, man.
What is the counterclaim?
Not ending on this is held it on the basis of the educated of the GPM.
Can you please tell the page number where it is?
On to claim page number. My lordship, page number
Please go to the IA, let's go. to the
41,
IA.
my lord.
You file the written statement.
Yes. Please, page number 41, my lord. Counter claim, my lord. They ran to permit to injunction.
I'm going to raise this with suppose suit.
Restraining the
permanent
plaintiff, anybody
injunction,
else.
restraining the plaintiff from interfering with the
Of the
principal position and
position,
enjoyment of the
when this would-
property. Putting up any construction, so and so. So and so, so.
After the cross-examination of PW1 and duty and penalty trial court imposed in my lord. The impounding order unnecessary of my lord.
Now let's come to the order impugn.
The unnecessary of my lord. Page number 52, my lord.
Yes.
And in page number 59, trial court paragraph number 2, my lord. As so far as the GPA, as so far as the GPA is concerned, as per the contention of the page number, contention serial number 6, page number 2, therefore, the vendor as authorized the purchase of the GPA to executed deed or deeds and admitted execution of the same before complaint authority, my lord. In the other words, GPA content vendor as
Relying
authorized.
on an agreement of sale,
Yes, ma'am.
and by virtue of that agreement of sale, you have been put in possession of the property is your case.
Possession of the property not to interest of the injunction, my lord. Counter claim. And one more is citation of 2017 surplus one.
First, let's understand what are the facts.
And trial court import the GP and duty and penalty, my lord. Page number 61, my lord. As so far as the above affidavit as GP has been impounded for collecting the duty and penalty since the affidavit labeled to duty and penalty of rupees 55 and GP of rupees 27,247. Totally different number 1 and 2 to have pursued same, my lord.
Yes. Yes.
Yes, my lord. And there I filed the application order of the one erection of the dishonorable court, my lord. 2017 AR, my lord.
Where is it?
It is unnecessary fee, my lord. Page number 62, my lord. Is here page number 64. Paragraph number 8, my lord. The duty and penalty, the stamp duty chargeable on a document as to be determined only on the basis of the related text made in the document and by the referring to provision of law under the document as charitable or duty as the date of the its the execution and by the interfering of the proceedings. The parties are prayer made by the plaintiff. The documents has to be considered to be stand of the determining the proper duty and penalty.
Yes.
Is grounds duty and penalty are to be imposed.
Yes, what do you say?
There are two documents are to be produced during the course of examination of DW1. First document is a sale agreement, which is produced at page number 44. Second document, this is a general power of attorney. And both the documents were imputed by the trial court. And trial court, office of the trial court directed the defendant to pay a sum of rupees 27,000. Out of which, the general power of attorney, which empowers the defendant to sell the property, which is required to be impounded, and the trial court rightly impounded and directed him to pay the penalty. Now, before the trial court, the defendant has filed an affidavit along with the document where it, my lord, under Article 41 of the Karnataka Stamp Act, the GPA shows that, my lord, when given for consideration and authorizing the attorney to sell the immovable property, the required stamp duty is, my lord, the same stamp duty as conveyance of Article 20 for a market value of equal amount of the sale consideration. The sale consideration shown in the document, my lord, 25,000. So, my lord, that is considered, he is required to pay that much of the stamp duty on that document. That is the only thing to be determined by this court, my lord. Insofar as sale agreement, my lord, it is in the form of affidavit and it says that entire sale consideration has been paid and he is required to pay the stamp duty as rightly raised by the trial court, my lord.
We'll consider what is the next.
Sale number.
Results are all.
My lordship, one more.
Please pass on. Take the judgment. Right, for the, right on that endorsed petitioner. Yes.
Sale number 19, Shankarappa S for petitioner.
For respondent in this case, no. But in this case, no, the
Some they said that they'll come up with a retirement memo. The other day when the matter came up, they said that they'll come up with a retirement memo. Just like that something is filed, this court has asked them, we'll pass over, we'll see.
Yes.
We'll pass over.
Some other day, tomorrow or Thursday or any date, no. Because we don't know that whether they will appear, come or
Post
not.
this matter on Thursday.
Much.
No representation for the petitioner. Yes.
Sale number 20.
My lords, I appear for the petitioner. My lords, this matter is pertaining to an interim order of maintenance passed by the trial court, family court at Mysore, please. My lords.
Where is the counsel for the respondent?
My lords, the matter has been continuously posted for multiple times. They had sought for adjournments, but they have not appeared.
No,
My
I
lords,
think on the last occasion, it is on the request of the petitioner.
my lords, I asked that this matter may be posted on a short notice.
The petitioner submits the court will grant and so seeks time to file his objections.
No, that was the respondent, my lords.
Today we'll hear it, we'll pass over and pass orders.
Grateful, my lords.
Inform him, yes. Next 21.
Sale number 21. Varadaraj MS for petitioner.
Respondent.
B. Vishwanath Shetty.
My lord, in this matter, last occasion, my lord is pleased to see their proposal for settlement concerned. On inquiry, I came to know that there is already a dispute between one Papanda and them. A suit is also pending, appeal is pending. And that Papanda also made an attempt to disturb our client's position along with another person. An order of injunction is also obtained against him. Suppose if he wanted to change according to him to another place where they are showing, again he has to face with this Papanda who is fighting with them. So this place they wanted to stick on and they do not want to able to again fight for another 30 years against Papanda and all. That is their grievance may not be. Otherwise, I made all my best efforts to resolve at the time, if possible, to go to that 30, 40 or whatever may be the extent.
Great respect to my friend. Papanda's dispute is not with respect to the property. A portion of this property came to be acquired by the highways. Papanda withdrew the compensation and ran away.
Can you please tell him what it is so that he'll put to his clients, what is his instructions and
Mila,
what your instructions? both
Suit
of-
decreed in favor of our client against
What
Papanda.
we do is.
Long back there.
1 minute,
Madam,
we'll
there are
have,
two-
1
Madam-
minute, we'll have it on
Yes.
Tuesday.
Please,
He'll tell you
Much
what is the
obliged.
dispute. Basing on that, we'll,
much obliged.
at the request of both the councils, post this matter on Tuesday. Yes, next matter.
Sale number 22.
Senior intermatter to be extended.
Intermodal earlier granted.
But
is
in fact, my lord, that is indirectly modified last occasion, permitting me to put up compound wall and to proceed with me, so that it cannot be continued again. It will be.
I myself will raise
But
the compound on
I'll
three
ask
sides,
my client not
opening
to do
it to the
anything.
national highway. If he wants to put up, I have no.
My lord,
But the
Intermodal earlier granted is extended in the next date of hearing.
in last date of
You
hearing,
convey the
order may
same to his
kindly be
client.
various.
Kept it open. Where is that? When is it modified?
No, my lord, last date of hearing, my lord's order may kindly be various.
With an offer.
Where I have
consider
been
that,
permitted to, please.
They can go ahead or else whatever is the
please.
land remaining after the acquisition, if he
Please.
keeps it open, it would be very difficult. Of the land and he has to construct a compound wall.
Please.
Council appeals because he would convey. court.
My lord, I'll wait till next week also, my lord. My intention is not to do.
No, there no such order is granted. It is only recorded.
After then, if it is.
But the
Extended.
original order is the impugned order.
Yes, yes,
exceeded.
yes,
That may
yes,
be
next
extended.
week, next week. Please tell him what it is, what you want to tell
Please.
the court now. About that Papanna,
Let-
that
let-
injunction, which is.
Let my
nothing to
friend
do,
furnish.
so that he can put a word to his client.
I'll make my further efforts also in the matter.
Yes,
Absolutely,
yes.
from my side, there is
Yes,
nothing.
yes, next
This,
matter.
if this property is already locked up with another litigation in Papanna. I offered him an alternate site.
That's why you can put that, otherwise next occasion,
very
we'll
well.
hear it on the merits of it.
I'm grateful.
22 KS Harish, Patil Jagdish Gaud.
Please, my lord, I appear for the respondent in the matter, your lordship.
Yes.
This is a matter, my lord, the company is under winding up. The official liquidator has been appointed. Under section 446 subclause 1, my lord, the permission of this honorable court is required to prosecute this suit. That's why this petition came to be filed.
Yes.
Lordship may kindly see the suit is annexed at annexure F. Page 74, my lord. My lord, I am seeking leave of this honorable court to prosecute this suit, which is at annexure E, page 63.
Page 63.
Page 63, my lord. Suit is for a mandatory injunction against the official liquidator. What are the facts of the case, my lord, is like this. It's a grant land, my lord, and subsequently, my lord, the grant has been confirmed. In the meantime, my lord, this property belongs to the company which is under liquidation, which is Krishna Rajendra Mills Limited. My lord, in the subsequent developments, my lord, when the company came to be wound up, the official liquidator claims that, my lord, this property still belongs to the said company. So, my lord, a suit for mandatory injunction is required to be filed. A suit came to be filed in the meantime, my lord, but the same came to be dismissed for the reason, my lord, the no permission has been taken by this honorable court. Hence, I am.
That order?
That order has not been produced, my lord, the order of dismissal. That dismissal, my lord, once again has been, a miscellaneous petition has been filed, and miscellaneous petition is pending there before the trial court for restoration. In the meantime, I had approached this honorable court
How
for.
can it be by both the ways?
No, my lord,
Any order that is passed by the court, you should come before this court.
Yes, my lord, that is why I am before this honorable
Where
court.
is that order? You have to assign that order straight away. How can you come and come?
No, my
by
lord,
way
the
of this?
permission is independent of the court, the civil
No,
court's
but
order.
ultimately, what remains is that you have already filed an application.
The application has to.
Order that is passed.
No, that is only for restoring the civil suit, my lord. But to prosecute the civil suit.
No, for restoring the civil suit, the reason why it is dismissed is that you have not obtained the
permission from
of this court. Now you want a restoration of the suit. That means you wanted an order of the court to be reviewed.
My lord, these two are two different independent proceedings, my lord.
That's the only issue.
The only issue before a lordship is just.
Not before this court, even before the trial court
right.
also, it dismissed only on the ground that
there was no permission
of the court. Then for the same order, you sought for some restoration. On what ground you sought?
No.
Those documents are necessary.
I will file the.
What is the order? What is the restoration petition you have filed?
I will produce the trial court records.
What's this matter on
May I make one submission?
Huh.
Basically, the writ petition itself is not maintainable.
That's what.
No, madam, I will make some submissions. But once the company is winding up, it is under the custody of the official liquidator. If any proceedings are required to initiate against the official liquidator, the company court he has to approach the company court by way of CA, company application only, not by way of writ petition. So therefore, the date of presentation of the company petition, it is under section 441. Once a company petition is presented, the limitation will commence. If any proceedings are required to initiate fresh, or if any proceedings are required to proceed the pending proceedings, he has to approach the company court by way of company application only. So therefore, this writ petition is not maintainable.
Yes, get those papers.
I'll get it.
Then counsel the petitioner shall file the order passed by the court below and the restoration petition that is filed. Yes, pose this matter on 23rd.
Oblige.
Yes, next matter.
For 23,
I'm for the respondent in this matter, madam.
Yes.
not for petitioner.
The 9th of this month, my lordship has interviewed the child in chamber.
Yes.
Please, your lordship had met both the parties in the chambers.
No, that day I've interacted. I think your colleague has sought for time on that day, please, to find out what in the interaction, what the court could understand is like that girl, is it the same case? That girl is
Yes,
She's
my
about
lord.
6
6
that
years.
baby girl, no,
Preterm.
she is 6 years, but she looks like very, is it the case?
Yeah,
Yes, ma'am.
Where she looks like she's a premature
the
baby.
premature child, but otherwise there is no abnormality
No,
or
no, but
growth.
what the court appeared, like what the mother is saying, she can't even tell anybody unless and until somebody asks her about that she's hungry, she has to go for the nature calls, nothing she knows.
No,
That's
your
what is
lordship, quite the contrary. She, in fact, gets fed by the father. All these are the visitation photographs, court officers, of course. And his mother, that's the grandmother, takes the child to the restroom. Child asks specifically. In fact, she had also complained that child asked for biryani and ate and all of that. So the child happily eats, plays, everything. It's a complete, trying to mislead this honorable court that if the child is then a special child, if is at first standard, is not able to say any of those things, then they
No,
should
she
have.
was saying that, for how many hours it is, she don't even ask for, like that she wants to go for that.
Absolutely not. In fact, your lordship could even appoint a court commissioner to go and see how the child is with the father all the time. Child is absolutely normal. And if she's claiming that the child is a special child or something like that, saying that even at 1 year, at first standard, no child's not able to do any of those, then means it's a special needs child. School would not have admitted this child into a first standard if the child was a special needs child. It's all completely incorrect. Child plays, eats, goes to restroom with the grandmother. Everything is done normally. This, your lordship, is completely to mislead this honorable court. In fact, any court.
And one more thing, I think if I remember correctly, what she says is the grandmother is not with the father.
She's very much here.
No, not here. She doesn't stay with him
No,
generally.
no, she's staying here only, your lordship.
She is not a resident of Bangalore, my lord.
So now only thing why this matter is adjourned is only on that ground, saying that the girl is not normal. She requires constant attention of the mother, which they are not giving. Those are the grounds which the mother has stated. And if as far as the grandmother is concerned, then whenever the visitation rights have to be exercised, the grandmother would be there.
My lord, the child is not comfortable. My lordship has seen the child is very timid also. And also he is enjoying visitation rights in the visitation room.
No, unfortunately, mother, what the other day she was saying, but she's not letting her behave like a normal child.
No, the child
She
is a
feels
preterm.
that, more than the girl, the mother might be feeling that she requires more attention. But definitely the girl is not normal, maybe because of the way the mother is bringing her up.
She has not met her milestones, my lord. She was preterm and all those
Why
things.
is she in first standard? She shouldn't be by this time.
So they do admit children in school nowadays. They don't differentiate. They do treat children, in schools also. There are schools which they admit children even if they are slightly on the border. But this child is highly timid. Even the trial court judge has interviewed the child. And there are observations that the child is scared.
Mother is being too overprotective and over-possessive. It is not letting her to, express herself. She should live like a normal girl. Why should the mother constantly, like, whether she wants to go to the washroom and all, also the mother has to ask. That is something very strange I felt the other day when I interacted with them as a mother also. Why is it so? She's 6 years old. And even if she wants to eat something, that also mother has to ask her. That's what she's saying. Is it not something very not normal?
It is slightly on the other side. However, when the child is not being forthcoming, the mother is trying her best. The mother is not of the opinion to burn bridges between the father and daughter. However, let the child grow a little older, maybe 10 years or something, then he can enjoy. Let the child develop a natural bond with him slowly. Why do we need to rush it? If it's the other way around, and if the child,
No, we have to give it a try. What's happening? Why, who is the mother to come to the conclusion and take a decision that 10 years we should wait?
no, I mean, I'm just saying this is my opinion as such,
No,
my
no,
lord.
in
So
the,
let this,
in the process, she's growing up. Let her grow up in a normal way like any other child. No, we
So
are not
he's-
making her to do something which she physically can't do. Now, meeting the father or having an interaction with them, if that is going to have hampering her any of her health, her other things, then we can consider about it. Now, if just because the mother is too over possessive about her, I think that is also not too good for her.
no,
So
mother is
at
not.
least, out of the mother's the attention, at least for some time, would help her. We'll see and work it out how it works out. Then we can see if it is not working out and something is not, like the child is not comfortable. Then we will think about it.
Already the orders that he's enjoying at the
No, but
visitation
let it
room.
be, why he should be in the mediation center? Why not at home?
200 meters away his houses. If there's anything
Because
a
we
mother
should
can.
travel all the way from here to mediation center when they stay nearby. Now, we'll make sure that whenever this visitation rights takes place, that the grandmother is there. If that is her apprehension that the husband cannot take care, that a woman needs to be there, then we'll ask the grandmother to be there. And let us see for 2 times. Then you can come back and tell the court what are the difficulties. Now, without even trying, why should we say that no, it can't work out?
Because overnight stay was an issue, my lord.
No, where was the overnight stay?
That
We
is-
will
that's
not
the-
say now.
No,
At
that
this
is
point
the,
of time.
because see
We'll not
the,
say, what we do is, for the next 2 visitation rights, let her be there during the course of the day in the house to be exercised visitation rights. Then we will think about the other things, how this goes on.
Please.
because what he has prayed for in his IA was for overnight to grant
that
him
can be
interest.
We will not
later,
consider,
please.
that this court is not considering now.
Okay, my lord, 1 to 5 at his house would be appropriate.
1 to 5, why?
Let it start with 1 to 5 for 2 weeks, and then we'll come back to this honorable court and we'll report what has happened.
No, it can be about till 1
12 o'clock,
Let
12
us not-
o'clock to 5 o'clock. 12 to
Let us
5.
not stress
12
the
to 5.
child, my lord. My
No,
only
no,
concern
12
is,
to 5, 12 to 5. In between, if the child wants to speak to the mother also, father will facilitate that.
Please.
He will facilitate that.
but in the event the child does not want to go and she's holding on
No,
to a
that
mother.
is something like,
200 meters, we will take
in
the
every
child back.
case, that is one question. And she is not the one who will who will say no also. I've seen her. For everything, she has an answer, yes. We'll see. And tell the mother that let her not come up with such an answer. It's not right. And then the court will be compelled to pass some other order. The girl will go. Where is the order passed by the trial court?
Please. Lordship at page 70. 73. Your Lordship.
The trial court, by order impugned in this writ petition, has granted visitation rights to the father twice in a month for 2 days during the weekends. No, instead of giving it twice on a Saturday and a Sunday, what we do is this week, next week, let her exercise on a Saturday.
Please.
And
The
then let her
order-
come on that Monday, then we will see.
No
Instead
problem.
of 2 days,
Please,
twice.
please. I give it to your Lordship, please.
Lordship, the order is first and third Saturday between 1
No,
to
it is
5.
first, not twice a day, twice a week.
Order
days.
on IA number 8, my lord.
No, if you see at page number,
IA number 8 is filed under 151. I'll be permitted to read the order. It's
first and
directed.
third Saturday of every month in between 1 PM to 5 PM.
Yes, my lord.
Court had ordered the visitation rights for first
First
and
and
third
third.
Saturday of every month in between 1 AM to 5 PM where is the mediation order?
Mediation center, your Lordship.
Where do you get that?
Visitation room, it says, your Lordship. That is the mediation.
visitation
It's directed to hand over custody of
No,
the child
in the
during exercising
visitation room.
visitation rights.
Then counsel for an IA is filed seeking overnight custody. And also it is stated that both the mother and father live very close by, within 200 meters. And they're traveling all the way to go to the mediation center. Then on the last occasion, this court had directed the parents and the child to be present before this court, and this court has interacted. On that, the mother had stated that the child is very timid, child is not comfortable, she do not understand, she's aged 6 years, but do not even understand, and she can't even ask for her the basic requirements, neither for the food nor for the natural call. The mother has to remain the same. On that, to get instructions on that, the matter is posted to today. Today, when a senior counsel appearing for the petitioner husband submits that, in fact, she is very comfortable, and certain photographs are placed before the court to show that she was comfortable playing, eating with the father and the grandmother. On the last occasion, when the mother interacted, it is also her apprehension that only the father stays and he cannot take care of the child. It is submitted that the grandmother is there, and whenever the visitation rights were exercised, the grandmother would be there with the father, considering all this. And at this stage, this court cannot consider the submission of the learned counsel for the respondent mother that it is not, the girl will not be comfortable unless and until it is tried and understood. That cannot be said that the girl would not be comfortable, considering all that. This court deems it appropriate to make an interim arrangement whereby on on 20th and 27th, the father can exercise the visitation rights between 12 and 5. He can pick up, or the mother will drop.
Let him come and pick up the child.
The father can pick up the child from the mother's place and drop her back. In between, if the child wants to talk to the mother, father should facilitate her, and he should also know the routine of the girl, and accordingly he should take all steps. And basing on the visitation that takes place on these 2 days, further orders would be passed. Post this matter on 23rd. 23rd? No. Post this matter on 29th.
Your lordship, normally on picking up also, she creates a little trouble. So if that she will smoothly.
And the mother.
She will participate, my lord. She will participate in this, because after this, they'll go and file contempt matters that she is not participating. This opens the door for the litigation.
What is that?
No, she will participate in allowing the child and handing over the child.
The
If
mother
direction.
shall not create any kind of disturbance, and she shall, as per the orders of this court, she shall hand over the child to the father.
My lord, I may request that both the parties not to create any disturbance.
Both the
Both
parties.
both the father and mother not to create any
Father
disturbance.
so far never.
Both the father and both the parties
Both-
shall not
both the
create
parties.
any kind of inconvenience to the other, which will be viewed seriously on the next date of hearing. If anything of that sort is brought to the notice of the court.
Obliged, my lord.
Date may be fixed, your lordship.
29th.
29th.
Obliged.
Yes.
Cell number 24.
Obliged, my lord.
Raghu Prasad, BS for petitioner.
Seal number 24, take for weeks time, kindly next week back. In the meantime, I produce a document. All 4 connected matter may be next week, any date. Please.
Why you want adjournment?
I want to produce salary certificate of my husband. Therefore, I sought for the
When this matter came up earlier before the court?
last 2 days.
Huh?
Sorry, my lord.
5/7.
Twice.
You have an interim order in your favor?
Yes.
Then I post this matter on August 12th,
Obliged.
at the request of learned counsel for the respondent. Yes.
Number 25.
For the
Puna
petitioner.
Shekhar, Media Mandki for the
This
respondent.
petition is for the enhancement of the interim maintenance. I have filed the application.
Much is granted
I have
50,000.
sought for 9,50,000
per month.
per month,
Uh,
but paid 50,000.
Court granted 50,000. What is the salary?
He is a multi-billionaire. He's a high net worth individual. He has several business organizations.
So what is the evidence before the court? Please.
I have
confirm.
furnished
Come to the order.
Page number,
Wife and a child is also there or the only wife?
wife
Wife
and
and two
child.
children, my lord.
After.
Daughter lives
after
abroad,
20
my lord. She's studying.
Hmm?
Daughter, my lord, is pursuing her master's abroad in the US. Son, my lord, is 15 years old. He's here with the mother, my lords.
With the mother.
With the mother.
Who are bearing the expenses for her education?
Yes, my lords. No, my lords, my father had created a trust, my lords, a personal trust that takes care of all their education, my lords. The children's education is taken care of, their expenses are taken care of. These trusts are made only in respect of the grandchildren, my lords. So they take care of everything there is to be done.
So mother need not pay the education expense.
No, not at all.
From how long they are separated?
My lords, from 2022 onwards, my lords, 2 years.
Who filed the MC
I have filed it, my lords. I have sought for divorce
on the ground of?
on ground of adultery and cruelty, my lords.
Hmm. So please come to the order, impugn.
The conclusion of the trial court is you have not furnished the proof of the income of the
Husband.
husband. It is admitted fact that page number 76, in page 76.
Has he filed his statement of assets and liabilities?
Yes, my lords.
both of filed.
So what do he say?
As for asset and liability,
Where are they?
page number 99, wherein he says he has taken a loan of 2 crore 50 lakhs.
Let's see. Statement of expense.
Page number 99.
No, come from the beginning.
91, my lords, annexure G. My assets and liabilities. my lord.
90?
91. my lords,
91.
on
Let
page
us look at his assets and liabilities.
Yes, my lords.
Masters in robotic engineering,
Yes, my lords.
monthly expenditure 15,000.
Yes, my lords. My lord-
70,000 per month is your?
My lord, no, my lords, that's my friend that I'm living with. It says, my lords, if not staying at matrimonial home, we are not living together. Relationship and income of the person with whom you are staying.
Your age is 60 years. You are staying
60
with your
years.
friend.
Friend right now, because there is a dispute, my lord. My lord, I may simplify, my lords. If
No,
my,
no, whether let us see whether your spouse has claimed maintenance from his home. Let us see.
yes, my lords. yes.
Pending litigation. Then expenses incurred on this litigation, 50,000.
My lords may then turn to 93, my lords. I'll take my lords to the relevant.
Kindly peruse,
Initial profile of so and so graduate, this was is on it, approximately 1,000 per month.
kindly peruse page.
Particulars of the assets and liabilities of yours. Investment worth rupees?
15 lakhs.
Hmm.
I have two properties, my lords, of which one I have
How
sold.
much expenditure has been incurred on the children's maintenance, children's education, on the rate of separation till now? 1 lakh and 10 lakhs. So all this at 38 are taken care of. Look at 38, column number 38 in page 93
Yes, my lord.
are taken care of.
At 38, yes, my lords, all taken care of.
That is 1,27,125
Yes, yes.
per
yes.
month,
Yes, my lord,
per month.
per month. Whatever education, my lords, I permitted, my lords. I'll produce the trust deeds. The will is also produced, my lords, by him.
Next,
Submission.
interest on bank deposit and FDRs, 4,000 per annum.
Per annum.
He is spending per annum 1 crore 20 lakhs
See,
towards
let's
the
see
education.
from his statement.
Yes.
From the statements, we have to see
Yes.
monthly rent 5,000, household expenditure 10,000. Children, maintenance or dependence, and so. Legal litigation 5,000, any other loan. No, what is your income according to you?
My lords, I have no income.
How come you're paying this loan?
Yes.
For 2 crore 50
I
lakhs?
have repaid the loan. In fact, my lords, if my lords may permit me, my lords may kindly turn to in page 100, my lords. I have purchased, I had a property, my lords,
So at least your expenditure is
Yes.
1,52,000, that is including your children's expense.
that is the children's expenses, my lords, which is taken care of by the trust.
Yes,
My lords, if I'm permitted, my lords, I shall produce the trust deeds and also.
Not that the trustees, from what that you have stated, statement of assets, present estimated market value for your properties.
Yes, my lords, 1 crore 10. Now,
Hmm.
my lords, I have sold that property in Madurai, repaid my loans over here. During the pendency of all this, that this is the development that has taken place. My lords, may kindly permit me, my lords, my lord,
Balance in your current bank account,
24,000 rupees.
26,641.
Yes.
Then what are the other material you have filed?
Yes, committed a perjury, my lord. Page number 111.
Hmm.
Yeah, before,
Then the
after
court will take
23
care
years
it
of
if it is
marriage,
perjury.
after 23 of marriage, he is coming and making a false allegation wherein he has taken everything from the petitioner. First, he has taken
We are not on that. No, we are on the maintenance.
maintenance.
Now what he has filed, showing anyhow do not match any of your number of 9,50,000, his income or whatever it is. Now, what is the material you placed
Material,
before the
page
court?
number 111.
What is this?
That's the
Say,
will executed by
will,
by my father.
I will go through the contents of the will, my lord. Shidambaram Mahalingam is the father of the
What is that
petitioner.
flows from
Petitioner,
this?
yes.
Yes.
He has transferred everything to his father, gifted everything to his father. Later on, with the help of the his family trust, he has transferred to the trust, wherein he is the beneficiary. He have all the control over the business organization and then family trust. He is enjoying. But here, and he has committed a perjury by saying he doesn't have any income, but indirectly he has a lot of income. Wherein I have furnished a memo dated.
If the property is transferred only to do, not to pay the maintenance to the wife, now
Yes,
from a
plan, my lord.
trust will work as per the whatever for what purpose it has been established.
Yes,
How can he withdraw the amount from the trust?
He is the beneficiary. He has a control, wherein, so here clearly says, page number
raised
112.
all these grounds
Page number what?
Have you raised all these grounds before the court?
Yes.
Whatever, let us see your IA file for
Yes, ma'am.
maintenance.
Annexure D, my lords, page 64.
64,
my lords, in page 64.
I have stated in the affidavit.
My lords, may kindly see
Here-
64,
here.
my lords, before the affidavit, my lords.
So they used to live in the.
3,50,000 towards salaries, my lords. 3,50,000, my lords, is the claim towards salaries.
Household.
My lords, inflated, my lords.
Is not-
1,50,000 towards medical expenses.
My lord.
There is no
they are not a
medical
common people.
emergency. My lords, 2,50,000, my lords.
They are staying in a villa,
Even
which
today.
is measuring 11,000 square feet. To maintain that, they have to spend per month 2 lakhs rupees. From gardener to cook to everybody.
We'll continue after lunch. Yes.
What's its permission for it?
No.
Scene number 40, my lord, where the mother has come from Gwalior along with the child.
So I asked tomorrow can be. Because afternoon and in the evening there are two.
I have no objection. The petitioner's counsel also is present online.
Yes, tomorrow.
Please,
Tomorrow in the
please.
afternoon.
My lord, may I submit one thing? It appears that both of them appeared before the mediation in Delhi pursuant to Supreme Court order, and both the parties said, my lord, that this matter we will request jointly that the matter be deferred because 30th is the date, my lord, so before which the mediator in Delhi has to submit the report to the Honorable Supreme Court.
No, that is a different aspect. No, what is before this court is like the wife had agreed, as per that the court had passed an order.
And that's not agreed, and the wife has now come, my lords. Now, in the meanwhile, has come and stayed till now. Now, my lord has called today at 2:30. The child school has started there in Gwalior. One aspect.
No,
Today is the school.
when has she booked the tickets? That's what I'm asking. If it is tomorrow, if
This-
she can wait till
It's for
tomorrow.
today.
we'll pick it up.
Today night.
When are you leaving? Tomorrow morning.
But I will book day after, my lord. Ultimately, I am supposed to pay the flight expenses.
No, it's a question of child also. One thing is, my lords, may I request this, now that this honorable courts, my lords, has all the powers to.
No, when did you came to, on Friday you came?
Please. Now, my lord, this honorable courts, my
We'll
lords,
take it- We'll take up at 5:30, be safe.
Today.
today, my lords,
Very.
We'll take up at 5:30.
please. Hope there will not be any inconvenience to the honorable court because evening after 5:30.
No, but anyway, she has to leave. It seems she has come about 4
Please,
days
please.
back.
This aspect also, my lords, is probably the joint submission of both of us because as per the report, since there is a direction to the mediator that he has to also finish. Now she has to participate there also, my lords, and here also. If my lords is pleased to hold it, my lords, till that mediation happens, that would also serve the ends of justice. If it fails again, we'll be back before the
That's
court.
what, that order, we have to pass. We have to pass a subject after talking to her, what has transpired
Please,
and
please.
the
Yes,
orders
yes.
that are
That
passed.
you allot
No
time.
further, because when something is pending and there is scope of mediation, why would the court interfere in that?
Please,
It
please,
is
please.
only in the
Your lordship.
meantime to take care of
Your
both
lordship's
the
time is
parties.
also precious because honorable court has to sit after
Yes,
the court
yes.
hour.
Yes, yes.
Yes.
5:30.
Great.
Pass out.
Passed over matter.
Yes, in 24. No, if you remember at that point of time, it would be less work for the court. Because again, they have to start everything. Interim order earlier granted is extended.
Any consummation. Even on the 7th, I apologize for not being there when it's called. And the petition was questioning the.
Serial number?
7.
What has happened to that?
I was challenged the other part in the idea of.
No, what has happened now?
So I compared with the stay condition, Your Lordship. I also deposited the amount and also.
It is coming up tomorrow.
Under the headline of dismissal, but. I-
Delete from the caption dismissal, post tomorrow. It's already signed, it seems. Here only I've signed in the morning. itself. No, the file is already sent, it is signed. Yes.
Passed over matter, sale number 15. Ayesha Rupin.
So you please come back with what he's saying.
The compromise petition also.
No, what he was
They are
saying
not
is,
agreeable.
no, what he is saying is, tell him. Mr. Counsel, tell him what I'm saying. No, what morning it is submitted is that they are not agreeable for partition of the land. Whatever you have paid, at 6% interest from that day till now, they will pay the money.
That is the reason I am telling my lord. I gave them, each of us take half of each property. I did the compromise petition and gave it to them. They are not come back with them.
Tell him that.
One more. Morning, they are also filed one more memo along with the objection. Now, there is any objection regarding
It's not
that.
served on me. Not served on.
Once
No, please look at that. No, anyhow, both of you can't have that. He says they're ready to give money. Please look at that and get instructions from your client. Post tomorrow or on Thursday? Tomorrow at 2:30. At the request of Lord Gauns for the respondent. Yes.
Sale number 20.
My lords, I appear for the petitioner in this, please, my lords.
Have you served on them?
Yes, ma'am.
When
Yes,
was
my
it
lord.
served? Statement of.
I've been served with the copy, please, my lords.
Artist will also.
1 minute. No, what is the amount granted by the trial court?
It's 50,000, please, my lords. 50,000 per month towards
And
interim.
when is the interim order by this court?
The interim order by this court has been vacated long before, my lords.
When was it granted?
It was granted, please, my lords.
February 2022.
February 2022. Directed to the
February 2022.
22. And directed the husband to pay how much?
35,000, my lords.
When was it vacated?
Vacated on 2/9/2022, madam. Because
2/9?
2022.
So it's hardly for 7 months the stay was.
Yes, my lords.
Only for 7 months the stay was. So what is the memo of calculation or what did he file?
My lords, I filed 2 memos as per the directives of the court.
It is ready to pay 35,000 according to the.
Pardon me, my lords. That submission is incorrect, please. My lords. That submission is incorrect. I was asked to give a calculation insofar as per the interim order and also as per 30,000. I've never stated I'm ready. I've only brought it to the court's notice that I've been paying 15,000 a month.
Where is that?
And the memos, please, my lords, were filed on 18/4/2024, please, my lords. And as per that, I've been paying 15,000.
32 months interim maintenance.
Only the par number 4.
And whatever arrears were required to be paid as per the interim orders I had undertaken. But they've refused those terms, please, my lords.
So let's hear it on the merits of it.
Grateful, my lords. If, with the permission, my lords, if I may.
Where is impugned order?
The impugned order is at page 38, please, my lords, 38 and 39 of the writ petition, my lords. So if I may if my lord peruses on page 38, the last 3 paragraphs, please. The petitioners have taken the contention that the respondent is working as a software engineer at New York and is getting a salary of rupees 6 lakhs per month. Admittedly, the petitioners have not produced any income proof document of the respondent. Admittedly, though notice has been served to the mail address of the respondent has not come forward to appear before this honorable court and to say with regards to the contents of IA number 2. True advocate for respondent filed undertaking memo to file wakalat on behalf of the respondent, but till date, counsel has not filed wakalat and not filed objections to IA. At this instance, my lords, I need to submit. He was working in the US.
So by the time this order is passed by the court, there is nothing to show what is the income of the husband.
Nothing, absolutely nothing, my lords. Nothing was placed on record by the respondents herein to show that my income is 6 lakhs.
Then we will do one thing. You continue to pay 35,000. Let the court decide it. Let all that be filed before the.
My lords, subsequent to that, I filed a document, please, my lords, which shows my salary. The issue was not.
No, why did you not file before the court?
I was in the US, my lords. I was not even in India when the matter was filed.
Now file it. Till such time, continue to pay 35,000.
My lords, the matter is right now posted for arguments on the merits. Even till date, no document has been filed stating that my income was 6 lakhs.
Is it not your duty?
My lords, I have filed my documents. I have clearly filed it. If my lords peruse on. I filed an additional set of documents on 21/6/2022. Right now, my lords, at the time I was employed in US, I was gainfully employed. But then subsequently I came down to India for this matter and a criminal case came to be filed. Both my visa expired, my passport is no longer valid, and I lost my job. Following that, I've been working in Bangalore. And in Bangalore, I've been earning 18,000. And for that, I have filed my bank statement, which clearly discloses the income. Even then, my lords, I've been paying 15,000. I have not shied away from my duty. Whatever I am earning, I'm paying. Till the matter which was filed in 2021 is not being taken up by them. They have been protracting. Following the matter being posted for arguments, they come up with an application under 91 stating that now you file all the bank statements from 2018. They've been protracting these proceedings to an extent where I have been brought, instead of the wife, the husband has been brought to financial vagrancy here. Whatever I earn, I am paying. And I will not shy away. It is my duty and I will abide by it. But to what extent am I being harassed? Since 2021, they've been enjoying this order and not addressing their arguments, not coming up for evidence. At the nth moment, when the Honorable Court had posted it for arguments, they come up with the 91 application. They asked me for my visa and passport, which I've supplied. In 2022, please, my lords, both my visa and passports have expired. Until date, they go on stating that.
You're telling about so many things, sir, but you forgot the fact that you have to comply with the orders also.
Because I do not have the financial means to comply. I do not have the financial means. I'm coming before this court and stating this because I do not have the financial means. My financial means permit me only to pay 15,000 because I am earning 17,000. I am living at my father's place. And till date, I am paying. I'm not shying away from that.
At the time of filing the case also, the petition before the court, my lord, is not narrated in single things before the court. And moreover, is represented by the GK order in the kindly see to my lord. In the entire petition, my lord, is clearly mentioned in the brief facts.
When did you come to India?
My lords, 2024, please, my lords. Pardon me, 2022, the complaint is there. I've filed it. I came to India in 2022, and immediately after, when I reached India, 3 days later, a police complaint is filed under 498A, because of which I cannot travel abroad. I came down for my brother's wedding. The moment I touched down in India, 498A came to be filed, and I cannot travel now anywhere outside India.
Not produced anywhere in bank statement, Madam. Nowhere is produced.
My lords, pardon me, I have produced the bank statements on 18/4/2024, and a copy has been served. Copy has been served. If the court peruses the bank statement,
He's also obligatory duty on the husband to maintain the husband wife because of the small children.
Two children.
no, my lord. Only one child, no two children.
The order passed in C miscellaneous number 445 of 2021, whereby the court had granted maintenance of an amount of 50,000 per month to the petitioner, to the wife and petitioner and the two children.
Oh, pardon me, my lords. There's only one child. Only one child. I don't have two children. It's only one child.
Towards the petitioner, towards the wife and the children, towards interim maintenance, and 25,000 towards litigation expenses. The husband is before this court. When this matter came up for admission, this court had granted an order on 25/2/2022 to granting stay of the impugned order subject to the petitioner paying an amount of ₹35,000 on or before 5th of every calendar month, failing which the interim order stands vacated on its own. Later, as the petitioner had failed to pay the amount, the interim order was vacated on 2/9/2022.
22.
2/9/2022. Then it 22. Then counsel for the petitioner submits that in the year 2000, before, at the time when the case is filed, he was in US. Thereafter, in the year 2022, he has come to India furthermore to attend the marriage of his brother. At that time, 498A case was registered, and he could not travel to India. His visa expired, and from there on, he was not working. Thereafter, he got a job in Bangalore, and now he is getting an amount of ₹18,000 per month. It is submitted that he has been paying 15,000 per month. Beyond that, it is not the capacity of the petitioner, and he is not in a position to comply with the orders.
My lords, if I may add, my lords, there's an issue. Though I am qualified as an engineer, the moment I file my resume, for all police verifications, this case is being popped up, and this is the reason I'm not getting a suitable employment.
He was not getting a suitable job, as whenever on a police verification, they are finding this 498A case, and for that reason, he is not able to secure the job. And counsel submits that all these aspects had to be considered by the court. And his present financial position is also one of the issues that has to be considered by the court. And he submits that he is ready to pay an amount of ₹15,000 per month to both the wife and the children. And beyond that, it is the husband is not in a position to pay. Then counsel appearing for the respondent submits that the husband who worked in he submits that he's earning a handsome salary, and he's not producing any statements before the court. It is submitted that the petitioner has come before the court by suppressing all the material facts. It is submitted that it is a bounden duty of the husband to take care of the wife and to take care of the wife and to take care of the wife and children.
Ready to pay 35,000. The memo filed before this court also is completely.
No, that is what, basing on the court's this thing, yes, filed it, that how can we take it? The, what did you? Duty of the husband to pay, to take care of the wife, and also as a father, he has to take care of the child. It is submitted only for the purpose of evading payment of maintenance, is coming up with these kind of stamps. Next, having heard the counsels on either side, there is a material on record. There is no dispute about the fact that the husband was working in US and he came back to India in 2022. According to the husband, he couldn't get a job, and after he got a job where his salary is 18,000 because of the pending the criminal case, and whenever on a police verification, as it is popping, is not able to secure a job. It is further submitted that
this fact is nowhere stated in either the objection or petition. The first time is raised is the right.
Millards, the police case came after the writ petition, Millards.
According to the respondent, for the first time, this argument is advanced before the court. Looking at the statement of assets and liabilities, and also considering what has been stated before this court, to do substantial justice to the parties, this court deems it appropriate to give one more opportunity to the petitioner to submit all the bank statements and all the relevant records pertaining to his job 2018 to 2024, so that all the things will come to light with regard to the income of the husband, so that the court would be able to fix the maintenance in that view of the matter. And till the such application is decided, the petitioner shall continue to pay an amount of rupees 15,000 accordingly.
Millards, a time frame may kindly be fixed, Millards.
30,000 is reasonable. Is nothing, the agriculture property, everything is there, my lord.
This application shall be decided within 1 month.
Millards,
Arrears, at least in the meantime, my lord, arrears is also directed to comply.
Arrears at 15,000 shall be paid.
it is all complied, Millards. There are no arrears if it is at 15,000.
If at all any arrears shall be.
Grateful, Millards. Millards, direction to the trial court to conclude the matter in a short duration.
First the maintenance, next first maintenance, next the matter. Yes.
Yes, grateful.
No. Yes.
Greatly obliged.
25.
Now, you please tell the court, basing on what you say that deceases income. Now that what is happening to the trust, where that trust money would go, all those things, how can we consider it now?
My lord, he is the whole and soul of.
For that, the court has to appreciate what is the purpose and purport of the trust.
Just planned, when he turns 60 years, he filed the divorce petition on false ground. He has planned everything and then filed. He is divorced his first wife and then he married the petitioner in the year 1999. Now he is planning to marry other person. Her name is called Shilpa. That's where the problem is. Coming to page number 112.
Now, looking at the will and what has happened subsequently.
No, we are clearly.
What is the trust? By virtue, by the trust, what are the property? What would come to the petitioner? What is it? All that you have to demonstrate. Just like that, looking at it, the court can't understand.
My lord, it was executed by the
Grandfather.
Respondent.
Where is the trust deed here? Not will. No, according to you, all this property is transferred to the trust.
Yes, custodian of all the documents. Yes, that's where we have in the objection also we have said same thing. He has taken everything.
That's why it's better we look at the. That's why we better look.
Even gold.
We better look at the order of the court. We can't appreciate all that in a 227
mentioned in the 113.
Let's come to the page number order.
Page number 113, page number 113,
That will we can't consider.
here beneficiary clearly mentioned over. The respondent is the whole and soul, he is the beneficiary. He has all the control. Why? Because he doesn't have any document, otherwise we would have proved he has taken everything from without a clue, he has planned in such a way. Even he didn't even left a SIM card, mobile SIM card also. But the property worth of more than 7 crores out of coercion he has taken. Is in the will itself. After which he gives to his father, and then later on his father bills to the.
Please come to
trust.
para 20.
Para 20 of the petition.
Para 20, page number 29.
Yes, ma'am. Considering the above said facts and circumstance of the case, and also the fact that applicant responded is legally vetted wife of the petitioner, she is certainly entitled to the maintenance mandate life towards the maintenance of her son. However, no document is forthcoming from the respondent wife to prove the income and source of income of the petitioner husband as stated by her. Hence, in the absence of any documents evident to show the earning and source of earning of the petitioner husband, having regard to the status of the parties, income, earning capacity of the respondent wife, and also the petitioner husband, there are basic and reasonable requirements of the respondent wife or education qualification, also are earning, keeping in mind the present day cost of living, also the fact that son of the petitioner respondent is pursuing his studies and is under the care and custody of the respondent applicant. I am of the view that if the petitioner husband is directed to pay 50,000 towards the interim maintenance, interim monthly maintenance to the respondent applicant and her son pendant life from the date of filing of this IA number 3 and from 7/1/2023.
So, because no document is filed before the court has passed this order. Even till now, it remains to be the same.
I have furnished the salary receipts of the gardener. And
It is not about your expenses. It is about your income.
so it is not
So
available.
when he is not paying, where from you are paying all this receipts, all these
Trial
amount?
is started. At the time of trial, we can.
No, when he is not paying all that, you are able to pay all these maintenance to the staff. You have no income.
I've taken a loan.
My lords, when I
Taken a
paid
loan from,
9 lakhs
the
50,000, my lords, arrears, 9 lakhs 50,000 rupees check, my lords. I gave it to the petitioner. They refused to take it, my lords.
Arrears?
Arrears, they refused to take it. They said they do not want it.
No, we never said that we do not want.
Check
It
was
is a very
present,
meager,
my lords.
so the expense
They
itself
refused
to maintain that villa, it costs almost like a 2 lakh per month. So you're getting the 50,000.
Unfortunately, unless and until,
It is a very
unless and
posh,
until
as
this,
per my knowledge, that is a posh villa in the Bangalore.
it is not about you having a posh villa. It is about what is the income
It's
of
the
the
same standard
husband.
of living, my lord. They are not the common people.
How do the
Yes.
court know?
So I have, bill is there. Bill is there, even the website, his own website says, yes, I have furnished on 24th. of
Why
June,
did
I
you
have
not
furnished.
bring all these things to the court's notice,
My lord,
to
no,
the trial court?
no, trial court I have furnished, all the documents I have furnished.
No, by those
Here,
documents,
very,
can't understand from those, what is that the court can understand? By seeing the company's name, what is the income of the respondent, how will we know?
we need to furnish a balance sheet and all.
Huh?
Balance sheet of the
You
organization.
should have asked. You should have asked before the court below.
Trial is not yet commenced.
Huh?
Trial is yet to commence.
No, as far as this interlocutory application is concerned, you can ask. Why not? You should have asked all that. How do you expect this court to look into all that and decide, assume and presume things? Now, what is the stage?
Stage is, for now, they have filed amendment application. Now it is, they have to
So
carry
if
out.
you have any documents, or if you seek any documents from him, then we'll allow you, but it can't be enhanced as far as it stands today.
We are seeking a documents from all the organization, all the trust.
Please come. Agreed with the orders passed in I number 3 in MC number 5728 of 2012, dated 21st December 2023. The wife is before this court. Parties are referred to as so and so. The wife had filed a petition seeking maintenance of an amount of rupees per month.
More than
Sought
that,
maintenance of
his
an amount of rupees.
Sorry for the interruption. His admitted fact, he is spending more than 1 crore 20 lakhs to his children. He is saying he has taken a loan from Noble Office, but admittedly, which belongs to him. Clearly, I even.
That you demonstrate, all that we can't assume. The has sought a maintenance of how much per month?
50,000 rupees.
9,50,000 per month. The wife and husband are blessed with 2 children, 1 son, daughter is studying outside. Daughter is pursuing her studies outside the country, and the son is 15 years old, staying with her. According to him, according to the wife, his husband is a multimillionaire, and she has sought this maintenance. The court below had granted maintenance of an amount of rupees 50,000. The court has observed that except stating that husband is very well off, no other document is placed before the court, and accordingly an amount of 50,000 is granted. The next parallel, and counsel appearing for the petitioner wife submits that there are vast properties, a will is executed by the grandfather in favor of the father, his father, in favor of the petitioner's father, and thereafter.
No,
I am not the beneficiary.
No, that is a wrong.
Petitioner's father,
Has executed.
No, my lord.
I
My
am
lord,
not.
grandfather executed a will in favor of
He has
petitioner.
transferred all the alienation.
But my father has executed.
Let him say, yes,
He has executed a will.
father or grandfather?
Grandfather. The grandfather, respondent father.
My father.
Respondent father.
He submits that the
Initially-
respondent's father has executed a will and all those properties now are transferred to the trust. He submits that he is deriving a lot of income from the said trust, and he has stated he has stated he has misrepresented the court, and submits that he has as if he has no income. And counsel appearing for the respondent submits that in fact is living with his friend, and he do not have any that all the children needs are taken care of by the trust, and as far as the wife is as far as other income is concerned, then counsel submits that he do not have such income, and in fact he has sold the properties and whatever the debts that are there that were cleared by the husband.
House. She continues to live in, is provided by the company that I got. She continues to live there. Transportation, my lord, car that is provided by the company, she continues to use it.
It is submitted that the villa in which she is living, the villa in which she is living is provided by the husband. Even the transportation is also provided by the husband.
It belongs to respondent.
Having heard the counsels on either side, submitting on the court. The respective, both the parties are taking different stance. And ultimately, the court can only consider the evidence that is available on record. Admittedly, there is no evidence to show what is the income. Petition is taking, the wife is taking as putting forth her case, saying that he is having lot of properties And counsel when, during the course of the hearing submits that they will, if an opportunity is given, they will try to elicit the same. And accordingly, the court can fix the maintenance. Considering the same, the order dated 21st December 2023 is set aside and the matter is remanded back to the court below. However, till the orders are passed by the court, the husband shall continue to pay 50,000 to the wife. Huh?
Disposal of IA.
MC of which year?
2022.
Within 3 months.
Ali of life.
Yes.
Sale number 26. That one.
Which one? Where is it?
That is at
Forty? Why is it posted at 2:30? Yes.
It's a small matter, ma'am.
30.
But what happens? The parties
2:30
enter into a
matters.
compromise.
2:30 matter. One matter is at 2:30. Sale number 44.
Yes.
This is a matter where I did a lot of in-depth research, and that Radhakrishna Industries where Chief Justice Chandrachud says what emerges is it's a discretion of the court and agreed quarterly, and also he checked into the alternative remedies available. So therefore, in the facts and circumstances of the case, I ought to have, I could, realize something mess has gone. It is neither appeal nor WP.
So what is it?
And probably I will withdraw the petition with liberty to file an appropriate proceeding, and that could be review petition. And in that case, limitation period, if any, may kindly be waived.
So
to
what
the-
is this petition? I don't remember what it
Writ
is.
petition may not stand. Therefore, I don't press this one. I'll withdraw.
What did you question by this writ petition?
Judgment
Oh, judgment and decree.
It is OS, yes, in the partition suit. I'm seeking only for the modification of the shares. So there is no dispute about the reasoning and about the judgment. It is only modification pursuant to
Tell me
the
what is pending from 2021.
pursuant to the Supreme Court order in 2020.
No, whatever is the Supreme Court order, your remedy was to question the
Yes, yes,
judgment and decree, and unnecessarily 4 years' time you have spent here.
That has been gone into, and this is not even an appeal. I may have to go in review, seeking review of this. So therefore, if there's any, may kindly be permit me to withdraw.
Review of that order of 2017.
Yes.
Then it's all subject to limitation and all.
I will just check whether a limitation.
First, 2017 is the order.
It's 2007.
2021 you filed the writ petition.
Yes.
So already there, who will answer to that 4 years there?
I will cross check and.
But I can't, if it is whatever remedy available to you that you pursue, because court can't give you a liberty now.
Liberty, because since there is no time limitation for the WP, so therefore I
That's
think.
how you filed. But unfortunately, to file a review,
Yeah.
even if the court grants you some liberty for this from 2021 till now, but what will happen from 28th April 2017 to 21? When you filed a writ petition. So this court can't grant any liberty.
In case if there is limitation is attracted, it appears to me it may or may not be limitation in that, in any case.
No, limitation is there because for filing a review, there is a limitation.
Yes, yes.
And that limitation is it starts from, when did you obtain the orders?
For review mill, for appeal, there is.
Order copy was ready on
Yes,
7/6/2017.
yes, yes.
And you filed this writ petition when?
Writ petition we filed
5/2/2020.
5 to 20.
Almost 3 years.
5 to 20. 5 to
And it is numbered in 2021.
Yes, and.
So who will, how can the court grant liberty to you? It can't.
So
It is not that immediately after the order is passed within limitation, you have come before this court.
There, we have to explore some way out because
So
this
that's
is
why
a
what we say
matter.
that this writ petition is not
complete-
maintainable
Complete justice
because
has
you
to
have
be.
questioned the judgment and decree. So whatever is available, you have to pursue the court below. The present writ petition is filed, agreed with the judgment and decree passed in invoice number 2654 of 2000 dated 28th April 2017. Under a judgment against an order, judgment and decree of first appeal lies, but not a writ petition. Whatever is a clarification that the petitioner, it is submitted that only they are seeking a clarification as per the order of the Honorable Apex Court about the shares of the respective parties. All those things a petitioner can only seek before the appropriate forum. As this writ petition is not maintainable, dismissed.
It may kindly be stated that it is withdrawn. It may,
Dismissed as withdrawn.
it may just disposed of as withdrawn. May kindly be, not dismissed, because that will.
What is disposed of? Withdrawn is withdrawn.
Withdrawn should be, I will have some scope to further
You
argue.
can never say
It-
disposed of as withdrawn.
As withdrawn or something. Withdrawn should be a better word than dismissed, may kindly be.
Then it is withdrawn.
Yeah, yeah.
Dismissed as withdrawn.
I would like to withdraw it. I would, don't want to contest it and get the dismissal. So I just want to voluntarily withdraw it on the basis of.
Unfortunately, it has to be, either it has to be dismissed or disposed of. By withdrawing it, it can't be disposed of. So dismissed as withdrawn. Yes, next.
Kindly.
Cell number 26. Bharat Gowda, GB for petitioner. Prasanna Shetty.
It's the matter where, my lord, the parties enter into an agreement in the mediation center. Now, what happens, my lord, there is a typographical error insofar as the date of marriage is concerned. So the judgment and decree is also passed by the family court. Thereafter, my lord, I file a couple of applications under 152 as well as 151 also I file an application requesting the court to re-refer the matter.
Please come. Where is the order of the court?
My lord, the order of the court, my lord would find that page number, my lord, 52, my lord.
50?
Page number 52.
Why do you mention that number name, that wrong date right from the beginning? Your
No,
managed
in the
name.
petition, my lord, in the petition, the date of marriage is mentioned properly. In the mediation agreement, my lord, what happens? The date of marriage is 29th September 2014. My lord would kindly take annexure B, page number 34, 29th September 2014. But in the mediation report, my lord, what happens? 20th September. It becomes 20th September.
No, where is the order now?
Now, the
Dismissing
order-
your application. No, present application.
The present application that was filed by me, my lord, is in page number 55.
No, order.
The order, my lord. Annexure D, my lord, page number 49, my lord. And the relevant portion is page number 52.
52.
Please, my lord.
Dated executed between petitioner and respondent number is accepted and so and so.
Accordingly, in the marriage of the petitioner and
No,
respondent.
this
so
is not
much-
the impugned order.
This is, I have not impugned this, my lord. My lord, may kindly see my
No,
prayer.
you should have asked some application filed. What
I
has
filed an
happened to that?
application, no order is passed. No, absolutely nothing has been done by the family.
Where is that application?
The application, my lord, may kindly take at page number 55, my lord, annexure F. This I filed it under section 152, requesting
When
the
is it
court.
filed?
My lord, this was filed in June 2023 itself.
Nothing has been till now.
Nothing has been done. Thereafter, I filed one more application. My lord, may kindly take page number 61, annexure G. It was filed on 22nd June 2023. I request the court to re-refer the matter to mediation center to correct the typographical error. No orders are passed.
The present writ petition is filed. Signal direction to the court below. To decide the pending applications filed under section 152 and section
151 and 152.
160, section 152 and 151 of CPC. The parties have filed, the husband has, the wife had filed MC number 187 or 2020 seeking divorce. Thereafter, party entered into a settlement, and as per the settlement and as per the settlement before the mediation, and accordingly, a decree was done as per the settlement entered between the parties. wherein on order dated 18/4/2023, the court has observed that mediation agreement dated 18/4/2023, executed between the petitioner and respondent in MC number 187 of 2020 is accepted, and petitioner MC number 187 of 2020 stands disposed of as per the terms of the mediation agreement. The marriage of the petitioner and respondent solemnized on 29/2014 at Vaishnavi, solemnized on so and so, as per rights and customs prevailing in their community, is dissolved through the decree of divorce. And mediation agreement dated 18/4/2023 becomes part and parcel of the decree. Then counsel appearing for the petitioner as well as the respondent submits
Make
that.
one submission. My lord. Page number 23 may be kindly seen. The court makes some observations, which is the order sheet. After I file these two applications. my lord. My lord, the first portion, I filed the application under 152, requesting the court to correct the typographical error. Advocate for petitioner prays time to arguments with liberty for the advocate to address their arguments as and when the.
No representation, send back the record.
My lord, what happens? I file an 151 application to re-refer the matter to the mediation center. The family court mistook it as an advance application, and it would record that 151 application is filed for advancing the matter. And
What did you write? Decree. It is a case of both the petitioners that the marriage had taken place as per their when was the marriage according to you?
29/9/2014, annexure B, page number 30.
29/9/2014. The same was stated before in the application filed by them. It is stated that when it comes to the mediation report, it was mentioned as 29/2014. When they want to clarify this and file a petition before the court, which page you are referred to, 20?
Page 23, my lord.
When an application is filed under section 152 for correcting the typographical error in the mediation agreement, order copy and the decree, then the court had posted it to some other day. And when there was no representation, what is the send back the records?
Lord, what happens? I had filed since the matter itself was disposed, I filed an application under 152 first, initially, my lord. That no arguments, no date was fixed, it was just returned. Thereafter, I filed one more application on 151, requesting the court to re-refer the matter. My lord, may kindly see with the office notes says that it is an application filed to advance the petition, which was not. It was only a request to re-refer.
Later, an application is filed under section 151 of the CPC. Then counsel submits that the court below had failed to consider the same also. Next para. Both the parties, there is no, as per the remediation report dated so and so, the marriage between the parties is dissolved. In other pleadings, they have taken the date as
29/9/2014.
29/9/2014, whereas in the application, in the order, in the mediation, it is another date is mentioned. That is
20th.
29/2014 is mentioned. When it appears to be a typographical mistake, either any of the provisions, the court ought to have addressed the same and ought not to have kept the matter pending for such a long time. Ultimately, in the substantial interest of the parties, the court has to pass orders as the procedure is a handmaid of justice. And parties, the courts have to look at the substantial justice and considering the same, the court below shall pass appropriate orders clarifying the date of marriage within 15 days from the date of receipt of the copy of the order. Yes, next.
27. Adivar Jagdish Bhimappa for petitioner, Rashmi George.
For the petitioner, Milords. Petitioner is the husband. Husband's writ petition, Milords. He is challenging the order by which 50,000 was granted as interim maintenance, Milord.
How much is his income?
My lords, as on that date, he is an NRI. He was working in Dubai. As on that date, it was 10,000 dirhams. which is about 2 lakhs or odd. After that, my lords, a labor complaint came to be filed against him. His visa was cancelled and now he's back in UAE, but on a freelance visa. He is teaching music to children, keyboard and vocals. Therefore, his income, he doesn't have a stable income. It is about 5,000 dirhams, my lords, out of which 97,000 is his expenditure. To substantiate the same, on the last date of occasion,
So 5,000 dirhams is how much Indian money?
1,10,000. Out of which, my lords, 97,000 is his expenditure to.
What has happened to before the court below? What are all the documents that you have filed? What was addressed by the court?
My lords, my lords, I have not filed my assets and liabilities there.
What is this? When you have not filed your statement of assets and liabilities, why should this court hear it? No, it has become a fashion now in every case. You don't do anything before the court, come before this court, and this court again say, do that exercise. No, I'm thinking from now onwards, will not pass such kind of an order. Even to morning also, you have seen 2-3 matters and same. No, why the court has no other work? Why should they pass orders? Then again come before this court. Why have you not? Is it not that you have not given an opportunity?
My lords, I'm a resident of UAE. There must be some communication.
You are also now also a resident now.
Yes, my lords. That is why I have brought the affidavit. My
No,
lords.
the same things you could have done that time also.
I completely
Because
understand.
the resident of UAE we need not come personally. He has an advocate and he can instruct that.
I understand. I completely understand and what is following.
Above that, above what they say. Because they say that they filed this writ petition on the ground that they say there are only 2 grounds. One, they filed an application, objection to our application under section 36. Second is the trial court did not give them enough opportunity to file the ample opportunity to file their assets and liability affidavits. If the matter is referred back to lower court also, they may not do it. Why? Because we are filing this matrimony MC petition.
My lords,
on
I'm
16
sorry. I may not do it. I'll submit. I will submit. I will undertake to file my statement of assets and liabilities. I may not file it.
Milords, I have his assets and liability which he has filed in the criminal miscellaneous number, which I have filed along with the objection in this honorable court. That is the reason, Milord, because there is a pending arrear of 15 lakhs rupees in which we have filed an execution petition in execution number 195/2023.
Let us see his statement of assets and liabilities which you have filed in this.
Along with my objection, one he has filed in the DV court. That also, and there are various contradictory statements by the petitioner.
No, let us see first
In my objection, in page number 12 onwards. We not in that, in page number 15.
When did you file?
He filed.
Not you filed. When did you file?
I filed on 4/7/2020 for my objection. Because in the trial court, he is filing his wakalat on 27/5/2022. And we have filed our application along with the main petition on 16/11/2021. And then thereafter, he is filing his objections on 16.
It's not there.
11/20/21.
It's not there on record.
Because it is even reflecting in the system.
No, it is not there in the file.
I have been served.
They also having served the copy and it is given. It is reflecting this.
The registry is direct to place the objections filed by the respondent. Pose this matter on Thursday. Yes, next.
Number 28. Matter could be for the comparable code now.
We'll hear it on Thursday. Let it come.
28,
He has to also point out. We'll hear it on Thursday.
Very serious matter. He is earning.
We'll hear it on Thursday.
18/7.
Yes.
Cell number 28, Raja
Huh? 19th is not possible. If you want it, it will go to 23rd, 24th. 24th or 18th?
18.
18th. Yes.
Cell number 28, Raja petitioner.
This case appear for the petitioner.
Gopinath,
I have challenged the order of Annexure G in the respondent filed the application on 12 of the guardian not heard. So custody of the child,
Let's see, where is it? Page number?
page number. Annexure G, page number 48, in page number 48.
Yes.
In order 50, 50,
You're appearing for the father or the
father of the child.
order is it?
Order is in favor of the.
Where is it? Page number 40?
50, 50.
What did the court do?
Court is custody of the child in.
Line number 5, so and so is
Allowed.
allowed. Respondent is directed to hand over the temporary custody of the minor child
Child.
to the petitioner on completion of the academic year. School if any, if continued at so and so.
Now
Filed by whom? IA is filed by
respondent.
wife.
Wife.
Ah,
I, in the year 2021 is continued the child in study in the custody of.
what is the age of the child?
Child is 11 or 12 years.
12 years.
12 years.
Now, when the parties are separated?
Separated is long back. He is custody in child in 2021 is study in the school, my custody.
No, long, no, it's not long back. You have to tell from how long they're living separately. Huh? From 2021, they're living separately. So at the time of separation, now the child is with whom?
It was with the mother.
When did he go to the father?
The month of April 2021.
April 2021. Then you have filed this petition when?
Immediately we filed the.
When did you file the petition?
2 years. For the reason.
2022, you filed the petition. Seeking custody.
Yes.
Oh.
I produced the in study in mass card. Even the year 1921 is study in the custody of the child in the petitioner name. The already before the trial court.
No, why the court had completely given the custody, given the boy away to the mother?
Custody to the mother for the reason, Your Honor. Till 2021, the child was with the mother. She is taking care of the child. As far as the father is concerned, he is considered womanizer. He used to play cards, gambling, everything, Your Honor. So the mother is the only other person who used to take care of the child from day one. Even from the day one of the marriage, he is the only person.
Was that evidence on record or how it is decided?
No.
Please come to the
Page number.
Come to para 6.
From year 2021-22, they took it to the Mandia, it's a village, Your Honor. It's a remote place where they have taken the child, and the father, as far as the father is concerned, he is not taking care of the child personally. It's the parents who is the age-old parents of the petitioner hearing. They are taking care of the child. They are not giving proper education as far as the child is concerned. So literally mother has every time now and then she's traveling from Bangalore to Mandia. She's going there, staying for a day, taking care of the child, knowing everything, she has to come back.
Where is he working?
He is not working actually around.
Where he stays?
He stays in Bangalore running.
Native place.
Not staying one place around. That's the situation. He plays his casino and all, gambling, all these things. So that is what the major allegation is on. He never used to come even for 15 days, 1 month, it depends on. And actually like. No, he never took care of the child. He never took care of the child. No. Any portion of his staying with the, including the mother. No, my submission is, unfortunately, I have not filed the statement of objection. In the page number 44, in page 41, I was school in Jan 15/6/2021. I produced the mass card in the child, annexure F, page number 46. He is not studying properly in the, he is a rank student. He is mass card, page number 46. Even though
trial court is present before the child. Child is refused to going to the.
No, why should the child be studying in Mandya when both the
Native
parents
place, my native
are in
place,
Bangalore?
my native
No,
place.
why should he be? You are in Bangalore.
No, I have
Let's
studied.
see the cause list,
Wife
cause
is
title.
Mandya. I study my native place, land is there.
Your Honor, he made himself a submission before the trial court that is for 15 days or 1 month once he is visiting the child. Your Honor.
No, that is one aspect. No, all the while he was staying with the,
Yes, Your Honor.
no, all the while before this, he was staying with the father. Straight away simply saying that give the custody to the mother. No, the court has to see what's happening, whether the boy is comfortable with the father or not, whether the court interacted with.
My lord, what happened? He is not taking care of the child properly.
How?
He is not giving education. Your Honor, literally the child was not going to the school when mother was visited there.
That is your allegation. What is the material for that? No, basing on,
Documents which now they have produced, Your Honor. It is all says about the 2021-22, Your Honor. Subsequently, whether the child kindly peruse the pay slip, Your Honor, what the school fees, Your Honor. It says before 2022-23, Your Honor. As far as 24-23.
where are the details from 20, no, for the academic year 23 and 24, where is the fee receipt?
My lord, page number 44.
Page number?
Ink page number 44.
40?
4. In Akshata International Public School, 56 2000 is studying, 15,000 is paid. And next, and all annex
2021, 2022.
22.
We are
And all
talking about
annex-
23, 24.
And annexure F, my lord,
Page number.
page number 46. 22, 23 is mass card studying.
Where do you get the year?
Year
Academic year
is top
22, 23.
22, 23.
What is it?
Academic.
23-24, he has not gone for corporate.
That's what, where is 23, 24?
Yes, Your Honor. For that, he has not.
Now,
paid
please
proper
place
fees, Your Honor.
something with regard to 23, 24.
20, page number 46, my lord. Mailgade, top of this mass card, 22, 23.
I said 23, 24.
23,
23, where is he studying? Something should be there. You must have paid the fees.
23 is a new join, my lord, after repetition. I will produce the documents.
Not
And my one submission, child before the regent before, whichever husband is like and wife is like, each child is stated
The
before.
court ought not to have passed such an order. No,
My lord, what
they should have been, no, his boy is like 11 years old.
Yes, ma'am.
Boy is 11 years old. Why can't the court interact with the boy to know?
When child, when it is asked,
What, did the court call for the interaction?
not initially, Your Honor. Subsequently, after passing this order.
No, not subsequently. It should have been prior to this order.
Yes. No, Your Honor, my lord, what happened like the court, to insist that they are not appearing before the court. Subsequent to the mediation in the mediation.
Please come.
they are
Learned
only
counsel for the petitioner shall file the school receipts pertaining to 23, 24. Pose this matter on 23rd. Yes, next.
29, N. Gautam Radhanath,
24th, yes.
24.
Yes, 29.
Bill number 29.
I've received the copy, I've gone through it. This is the petition by the father. Lord, if I may, stop it to take.
Yes.
This is a petition by the father, my lord, if I may be permitted to take through the chronological events. The father filed with JNWC, a custody petition. Then the first order that comes to be passed was on 25th of January, 2023. I assigned that order in writ petition 25513/2023. The order is at page number 62 minutes. What happens in the first order is the father is given only 4 hours in a month in Bangalore Mediation Center to spend time with his.
First of all, what is the age of the child?
He's 6 years old now.
6 years old.
And Your Honor,
When was the MC filed?
JNWC was filed in the year 2022.
No MC is pending.
MC was filed, we withdrew the MC with liberty to file a fresh divorce petition because of some technical.
TNWC is filed by the father.
Yes,
Parties are living separately from when?
please, they've been living separately since 2021.
2021.
Please.
So you said 6 years boy.
Girl. Now, the bonding here, this is the case wherein, my lords, the child wants to go to the father, but the mother does not want the child to go to the father. That is the case. It's a very adorable child. Videos of the child crying that she wants to go to the after the visitation rites, and a few photographs, if I may be permitted to produce, my lords, to see the bonding. In fact,
No. Let us see the order. What did the court do?
the court just says it's a para number. One second.
Number 30 of the
30 of the writ petition. The court, it is, my lords, the court just says that the child is 5 years old. Therefore, the court does not grant.
What did you ask for?
In the first application which I challenged, this honorable court, the coordinate bench of this honorable court said, you approach again, file a varied application. Then I filed a varied application wherein I sought for overnight custody during weekends and 50% of summer vacations, winter and winter vacations and
Who stays with the father?
the petitioner's father and mother stay. My lords, in fact, I've read their objections. The petitioner's mother once met with an accident. Thereafter, what happened was she required blood transfusion. Blood transfusion was done. Unfortunately, she ended up being a HIV patient. Now, there are allegations that she is spitting in the food, my lords. I think that they should really not do that. She's a patient ultimately. As a grandmother, she has a right to see the child. I'm not even permitted to take the child to my place. At least, if forget about overnight custody, my lords, not even from morning to evening. In fact, the order that's been granted to the trial court is from morning to evening. That is around from 10 o'clock to 5 o'clock. In fact, I requested the respondent one day that my parents have come. In fact, he brought the grandparents there to the mall. She did not allow the child to meet the grandparents. Just because, my lords, she's an HIV patient. My lords, your lordship is aware as to how HIV spreads, not by touch. They should really, I think what they state, my lords, everywhere.
What did they say in the objections now?
Now they're making allegations of him being an alcoholic, and all these things have all of a sudden come up. From where? Because once the trial court granted 7 hours in a week, that is on a Saturday, on a Saturday. So totally I get 14 hours in a month. Then, my lords, the court does not grant me overnight custody and also 50% of vacations, my lords. Only one line is mentioned in the order. As discussed earlier, child is only 5 years.
Vacation is very long now. So what is now left is the visitation right.
Visitation right for overnight custody. Here the child is comfortable with the father. Here, this is not a case where the child is refusing to go. There have been other matters wherein my lords is aware where the child is refusing. Here, your lordship would not even have to interact with the child because of the fact and the videos and the petition and the photographs that she wants to spend some quality
Why
time.
can't you have the visitation rights during in a fixed time?
Please,
instead of having a overnight custody, considering the age and all.
Please, my lords, it may be tried out at least once, my lords, because the child, in fact, herself claims that she wants to go to his house. That is the, I have a video, my lords, if I'm permitted, I can play it. But, my lord, what happens in this?
child, then the child was first the order,
What did the child say? According to you, she is reluctant.
He wants to live with both the parents, is what the trial court told us. That's what the child says. The child says she equally loves her mother and father.
The father of the working is a photographer. He's out of station in the every station. In the overnight stay melody granted by this, he is unable to maintain the mother child mother. Then the trial court was after interaction of the child and parents of the child mother, the trial court was first the order. Earlier, the trial court was first order. 11 a.m. Visitation rate, 7 a.m. to 1 p.m. The petition was challenged that order before the honorable court. The interaction of the petition child mother, the modification of the order for 10 a.m. to 5 p.m. The respondent.
Now, let's just see how overnight visitation works out for a day.
Please.
The atmosphere of the petitioner house is not a good manner because the petitioner was illegal related with one another lady, my lord. Lady was Kanchan, her name is, Kanchan. And
His
the
cousin,
respondent is our-
his cousin, they're in alleging this. How petty can they get, my lords? Seriously.
The petition is not disputed that mediation also, my lord. And the atmosphere of the petitioner's house, my lord, is bad. Bad and mental reaction of the child, my lord, is.
My lords, if I may be prompted, one submission. What is happening here is, my lords, there is an order of maintenance which have complied with it in its entirety. Now, the mother wants money also from the father. At the same time, she does not want to send the child also. No, my lords, in fact, the petitioner has been gracious enough by not initiating contempt petitions. My lords, there have been totally 8 violations in the visitation rights orders. I in fact advise do not file a contempt because she is compensated, not all of them, my lords. I'm not denying that, but she's compensated a few of them. My lords, now it is for the grandparents to, we do not know how long the grandmother would live, my lords. Probably it's not in our hands. Is it
We'll
not
just
her
see one
right to
day.
see her grandchild?
The prior to first visitation that we have followed that order, my lord.
You know, that we are not going into. What I'm saying is, one day we'll just see on one Saturday or Sunday by giving overnight custody, what will happen. If you come up with whatever your objections, then we will review it.
Atmosphere of the petitioner's house, my lord, is not good and very much. Hence, I have praised that the conversation.
We'll say that the cousin should not be there in the house.
So she's not there anyways, only 3 people.
My lord, per month is 2 days of the granted, my lord. Another 1 day because they are granted, my lord. But the overnight,
Orange will do this way. Where is the station is where?
The visitation is close by to the residence of the respondent at a mall. He's exercising every time at the same.
Then we'll not grant the visitation rights. Let him during that period between now it is 11 and 1 they said. So we'll say between 11 and 4, let him take the child to his house.
Well, the
If
traveling
not overnight custody.
Well, it's to start off with. My only request is the travel becomes because he travels
To
from.
start off with, we'll do it. Please come.
Time may be
The
extended.
petition is agreed by the order passed by the court below, whereby the court had granted the visitation rights to the father on first and third Saturday of every month between 11 a.m. to 10 p.m. or 1 p.m. under the supervision of the mother. Then counsel submits that the the daughter is very much interested to meet the father, and the mother is not interested to send the child. Then the counsel for the respondent submits that, filed his objection stating that you should have filed it in the section stating that not necessary, stating that the atmosphere in the house of the petitioner is not good, is having extramarital affairs, and that his mother is suffering with AIDS,
Yes.
HIV, and that the weather that in the house, the weather, the atmosphere in the house is not congenial for the daughter. Considering all these submissions before this court, is inclined to pass an interim or is inclined to make an interim arrangement whereby the father will be on the coming Saturday.
The next
is on 20th.
And it's 27th, if I may request. 20th is got prior commitment, that being the.
On 27th, the father is permitted to exercise the visitation right at his place between 11 a.m. to 4 p.m. On that day, the father shall take the girl from the mother's place and shall drop her back by 4:30. If the timings shall be adhered to by both the parties and mother shall cooperate with the order.
May I request for us to pick up the child at 10:30? The travel is about 1.5 hours. That's the reason. If I could pick up the child at 10:30.
10:30, the father is permitted to pick up the child at 10:30.
Date will be fixed.
Huh?
A date.
Post this matter on 31st. Yes.
My lords, in respect of serial number 23, my lord, forgot to submit before lordships. Matter would have to be part heard because of the reason, because your lordships has already spoken to the child. That matter would have to be part heard.
23.
Serial number 23. Your lordship has in fact passed an order for.
No partners now.
My lord,
Yes.
because your lordship has spent enough time with the parties. Leave it to your
Yes,
lordship.
next.
Till number 29, 30, Raghavendra Shenoy for petitioner, till number 30. Dilraj Rohit Sikra.
Hello, it's my application seeking leave to file a counter statement came to be rejected, my lords. That's why I have approached. the
Your,
lordship.
your application to file a,
Counter statement, my lords, the main petition. This
Oh.
came to be rejected.
when was MC filed?
Lords, it was filed on 21/12, it was filed on 9/8/2021, my lords.
On 19/1,
9/8/2021.
2021. When did you receive the summons?
My lords, I entered appearance on 31/3/2022, my lords.
31/3,
2022.
2020?
Two. And my
So
lords,
when did you file this application?
before that, my lords, sir, matter came to be dismissed for non-prosecution, my lords.
On?
On 16/12/2022, my lords.
Dismissed for default.
Dismissed for default. They did not appear. Came to be dismissed.
When was it restored?
It was restored on 27/11/2023, my lords.
27/11/2023. When did you file the application?
After that, I filed the application, my lords, on 3/2/2024. So from the date of restoration, delay of 68 days.
Anyhow, you want a case to be decided on merits, is it not? Huh? Hmm. Page number? Please use the mic. I'm not able to hear you. Yes.
Thirty-first, 3/2022 to 16/12/2022.
Anyhow, I've seen all the dates.
Yeah.
Ultimately, you have to, and will say that no further adjournment, unnecessary adjournment should be granted. You find a case, you wanted to be adjudicated it unnecessarily, if it is kept pending, it is not good for you also.
But my lord, stating that silly reasons, on IA3, they stated that in Kuwait, there is no ledger paper where the population is 45 lakhs and what economy GDP is $49 billion something. There is no green paper. Instead, the council, the land council plaintiff, they are stating in that memorandum of facts saying that they sent through the VM
Yes.
email.
This,
Madam, if I may say,
application
madam.
is not worth any hearing.
Yeah, they sent that we are through the
No, there are no questions that are involved here that we have to spend much time on that.
In
Please
fact,
come.
my lords, I
even
find it
my
in the
lord,
white-
my lord, they are stating that they are sent through a mail and she took print of it. Said
Going into any of the technicalities, even assuming that there is a delay, that is between 27/11/2023 and 3/2/2024, matter of 3 months.
but stating silly reason.
So how does it matter? Now, why do you want, no,
Yeah.
some order is passed, now we will stay it. Or some order is passed, he'll go to the appellate court. Then unnecessarily, your MC is stalled.
My lord, we are seeking that let her come to Mangalore and file the counter statement. But she is not ready to file counter statement.
Different aspect.
I have filed the counter statement, my lords, but.
But it is not on the procedure of.
Rejected. That too was not.
Please come.
And so far as the white
An
paper is concerned,
application is an order agreed with the order passed in I number 3. In MC number 382 of 2021 dated 8th April 2024. The husband is before this court. Husband or wife?
Wife, my lord.
Wife is before this court. The respondent husband had filed MC number 382 of 2021 seeking divorce.
Yeah, on
Seeking-
cruelty.
Huh?
On cruelty.
Grounds of
On the
cruelty.
ground of
Grounds of
cruelty. In the said MC was filed on 19/8/2021. The summons, the respondent wife had entered appearance on 31/3/2022. Thereafter, on 16/2/2022, the petition came to be dismissed for non-prosecution. That was restored on 27/11/2023. Then an application came to be filed on 3/2/2024, stating that she was working in Dubai.
No, Kuwait.
Kuwait, and there was no ledger paper.
And also she is traveling globally, but she can't come to India.
On work.
No,
She's
work matters, but
constantly
it's a negligence
traveling,
on
And
what?
because there are no ledger papers available in Kuwait, as such an application, a written statement could not be filed.
No,
Yeah,
no, it
then-
was filed, Malats. What has,
For all these days, finally you have filed. When did you
Yes,
file?
But
Malats,
it's
I
written on the
filed,
procedure,
And
my
for
lord.
that, till such
Malats,
time,
I
they could
filed it
not
in the
file
white
it.
sheet, Malats.
They could not file it. When the application, when they sought the leave by way of this application, the court had dismissed the same.
On grounds of delay and
A
procedural
memo of
defect.
facts, it is contended that the respondent will visit India within 2 months from the date of filing of this application and furnish the objection in the proper format, or she can manage to file an objection through her GPA. Already more than 2 months have been lapsed from the date of filing of this application. No attempt is made on behalf of the respondent to comply with the mandatory requirement of CPC and also Karnataka Civil Rules of Practice. What is this?
Malats, that finding is, I'm challenging that finding itself, Malats, because if Malats may peruse Karnataka Civil Rules of Practice. Malats, Rule 3, Clause 2 states, Malats, pleadings shall include plain written statement, memorandum of appeal, cross objection, original petitions, applications, counter statements, what I have filed. Replies, rejoinders, and every statement setting out the case of the party in a matter to which the pleadings relate. Now, if my lords may see Rule 7, my lords,
Yes.
all pleadings, affidavits, memoranda, or list of documents and copies of documents presented to or filed in any court shall be fairly and legibly written, typed or printed on durable white paper. So as a matter of practice, my lords, we file it in the green sheets. But as per the rule, my lords, there's nothing barred. Nothing bars the parties from filing in the white sheet, my lords. The rules itself says it can be filed in the white sheet or azure lead paper of metric A4 size. The learned trial court has not referred to which rule, my lords. But the rule itself is very clear in this respect. I can file it in the white sheets.
My lord, stating the facts that there is no ledger in Kuwait, now stating this act, it
On the point of
doesn't.
law, my lords, it can
On
be
the,
filed in
on the
white
point of law, there is verification is not done. Instead of that, they can courier by DTDC or professional anything.
sheet. That would take more time, my lords.
My lord, even though they filed their petition, taking 2 months time, and instead of that, they can courier it, what printing of cross examination.
It appears that, heard the counsels on both sides. It appears that the suit is he had appeared appearance on 31/3, she had entered appearance on 31/3/2022. Suit is dismissed on 16/2/2022. No, 16/2. When was it dismissed? 16/2/2023.
My lords, it came to be dismissed on 16/12/2022.
By the time you entered appearance, it is dismissed.
No, my lords, I entered appearance on 31/3/2022, 31st of March
31/3/20?
22,
Correct. When was it dismissed?
16 December 2022.
16 December 20. When is it restored?
It got restored on 27 November
She
2020.
entered appearance on 31/3/2022 and it was dismissed on 16/12/2022. There itself, there are lapses on the part of the wife in filing the petition for about for about 9 months. Thereafter, when the suit is restored, again for another 3 months, the application for filing an application, they have taken the time. And the grounds on which the petition is coming before about the ledger papers are not there, all these kind of reasons cannot be considered. Clearly, it appears that there is there's an intention on the part of the wife to protract the proceedings. Had the intentions are clear, she would have filed her written statement way
if I
back
may,
in the year 2022 itself. You are supposed to file. When are you supposed
Yes,
to file
my
written statement?
My lords, even if that is the case, my lords, is a delay of 290 days in total, excluding the period in which from the date of dismissal and the restoration.
According to you, from the date of application, how many days you will get?
30 days, my lords.
So
An
when
additional 90
when
days.
did you file when did you appear? 31/3/2022. How
Yes.
many days there?
Yes, yes,
1 year.
if I may, true, my lords, but what has happened is, my lords, she works for a company, my lords.
Please don't tell all that. Those are not the
Madam,
concepts.
She can travel globally, not coming to.
The difficult, my lords,
Let her work, let her don't work. When the legal proceedings are pending, it is a duty.
my lords, one submission, my lords. My difficulty was, my lords, first she's in Kuwait, my lords. From there, she's in.
Let her be anywhere. That's her difficulty is not the
Lords,
concern.
we had a communication.
When the proceedings are pending, when you could file your wakalat, you have to do the other things. That is your lookout. Court will not consider all that. There appears
That's
to be
my
a
kindly-
delaying tactics on the part of the wife. And now
Kindly-
the submission that is made before this court that though as a matter of practice, green sheets are filed, the rules do not say whether rules refer to the white papers. All these things this court do not consider. In spite of observing all these, the court still wants to give an opportunity only to see that party gets an opportunity to put forth her case. Any of the objections, if they are not complied with, or the court has to, court can pass appropriate orders, and no further adjournments unnecessary should be granted to the wife, and she should not be permitted to drag on the proceedings. The present application is allowed on the condition of the wife paying an amount of rupees 5,000 as cost to the respondent. Yes,
Obliged.
disposed of.
For dismissal, cell number 31, Kiran BS.
On 7/6/2024, as there was no representation on behalf of both the parties, the matter was directed to be listed for dismissal on 13/6. Again, on 10/6/7, again on 4/7/2024, again this matter was directed to be posted under the caption for dismissal. Where is this memo of retirement filed with the counsel for the petitioner? The MMO is filed before the court. Now, how can they file these kind of petitions? The MMO is filed without disclosing any of the reasons, just stating that the client has instructed him not to represent it. And this court, when the matter came up on the last occasion, specifically has directed him to file the email dated 27/8/2021. There is no representation today also on behalf of the petitioner. Finally, post this matter on the top of the list tomorrow. Yes,
Cell number 32,
I think the list is there in that.
Respondent.
When our petitioner husband.
Hmm.
Now today I filed a NOC wakalat on this case. And also I filed the affidavit model as directed by this honorable court by wide order dated 2/4/2024. Copy, copy.
Then counsel submits that he has filed, is filing no objection to wakalat today. Post this matter on 23rd, no further adjournments.
Make it 24th, my lord.
24th. 24th is, 24th, delete from the caption for dismissal. Yes, 33.
number 33,
Oblast.
MJ Alva, for petitioner.
The petition filed by the petitioner.
Yes, for the respondent.
The petitioner is present
My
before
lord-
the court.
My lord, I submitting on behalf of the respondent counsel, my lord. The respondent counsel is not keeping well, my lord. Kindly have it next week, my lord.
No representation on post this matter for dismissal on.
Parties have come all the way from Akkalgud, they've traveled all.
Where was the direction?
My lord, last occasion, my lord, the council on record is appearing, my lord.
May kindly be perused the earlier orders, my lordship. This is the interacted
lordship,
before the chamber, my lordship. That it shows the attitude and conduct of the
Delete from the
respondent.
part heard.
Please.
Then where is the husband? No, neither the council represents nor the husband
My lord,
represents.
my lord, I appear for the council appearing for the respondent, my lord.
We will have
My
it
lord, he is
tomorrow.
not.
Tell him these kind of things cannot go on like this.
In the last
Even on the last occasion when there was a direction to appear before the court, the husband do not appear. Nothing happens. Now the matter is listed before the court. Today again they seek an adjournment.
My lord, last occasion, my lord, the council appearing for the respondent is appeared, my
And this
lord.
is
Petitioner is
the
not
petition
appearing.
was not present.
Please,
Petition was
on
not
last,
present. At the request of land counsel for the respondent, post this matter on 24th. No further adjournments would be granted. Delete from the
oblige,
caption
madam.
dismissal.
Even visitation rights also refused by the respondent in on 6th of this month, my lordship. The respondent is refused to visitation right of the mother before the CDP office. Is not bring the children before CDP office.
No, the council, nobody is there what to do. On that day,
My
we'll
lord,
pass orders.
kindly have it.
That day we will change the custody of the
Please.
children to the mother. Yes, tell him.
Great.
Oblige.
Cell number 34, hearing on interluxury applications.
Yep, the respondent, my lord.
Yes.
Lord, this application filed by the respondent for seeking, my lord, only the litigation expenses in respect of this petition is concerned.
In respect of this petition.
It is vision, that's what, my lord, already.
Very
last-
strange. How, under which provision now?
Under section 151 there, sir.
Yes.
Last occasion also, your lordship has said that, my lord, matter may be, because this application, because in respect of this petition is concerned, my lord, your lordship is directed to proceed with the main petition is concerned.
If I may submit.
Give that docket. Yes, we'll hear the main petition itself.
Please, madam.
Yes, please argue. Yes.
Lord, this petition against the order passed in execution, my lord. In execution number 146/2019, dated 19/4/2021.
Page number order, where is it?
Lord, the operation of order is 75 in page number
75.
The execution petition filed by the DHR. Original respondent is allowed with cost of, DHR is entitled to recover EP claim of rupees 4,04,733 from
How
the.
is it bad?
My lord,
Why is it bad?
but the reason is this, my lord, this is the order as passed in during the pendence of the main petition is concerned, my lord. Subsequent to the order, we preferred an appeal, my lord, against the order in page number 36, my lord.
How much was the maintenance initially granted?
Is 5,000.
So for recovery
5,000,
of
she has
that,
already received 5,000 rupees in another proceedings.
she filed this execution petition.
Against the
146,
recovery of the order passed in, on IA 7.
dated.
The order passed on IA number 7, my lord, dated. That is on 28/8/2018. In the main petition.
Then again, is that you preferred an appeal. What has happened?
My lord, because in the meanwhile, my lord, the appeal is pending, the original proceedings, my lord, MC has been dismissed. Therefore, my lord, I take your lordship on in page number 38.
30?
Yes, 38, my lord, please.
38.
8, my lord, please. In view of the fact, last parameter, the court has observed, in view of the fact that proceedings had already been fixed fixed for judgment, it is well less the file of the life of the interim order is co-terminus with the main proceeding at this
So,
point.
as on the day that MC is dismissed, till that day, you are liable to pay 5,000 rupees as maintenance.
That, my lord, if the fact is, my lord, that she is already received in another proceedings. She has initiated the 125 proceedings. Therefore, he said that
No, is it a bar that you can't have? If that is a bar, you have to question it by way of a
correct. Appealally, my lord,
legality
what
of the order.
happens?
So
Because-
what remains is, like, from till the date that MC is dismissed, and from the date of order
Date of
till that
order
day,
until the-
you have to pay.
But-
And why is it, what is it wrong?
our contention, my lord, because that we have challenged, because in view of this dismissal of appeal, for the reason that, my lord, original proceedings are terminated, and the account that I have lost the right to challenge this order, on the ground that, my lord, she has already get the benefit of the interim maintenance in connected proceedings. Therefore, we have challenged that, including that order in MC, that in MFA. Therefore, that ground we urge that it cannot be enforced against at this stage because the appeal is pending against the.
No, that's not the law. Please come.
May I just make a submission, my lords?
Yes.
My lords, very conveniently, learned friend has not mentioned that subsequent to this writ petition that was dismissed, dated 21/9/2019, he had filed another writ petition, WP number 7053 of 2021.
WP?
That was 7053 of 2021. That is produced as Annexa R3 in my statement of objections, my lord. My lords may kindly find it at page number 38, my lord, 36, my lord. In this, my lord, the order is dealing with the finality of the IA number 7,
How
my
can
lord.
another writ petition be filed?
My lords, he has done it, my lord, because the previous order has only merely stated that they are disposing it because the
Then
final
why
judgment
can't,
is
what is
reserved.
this? When an earlier writ petition is dismissed, how can you file another writ petition?
My lords, and in fact, it has been observed that the maintenance awarded is just and reasonable. And this IA has attained finality as well, my lord.
Please come. The agreed with the order passed in the execution proceedings. Page number
69 started by page number 69, 19/4/20.
Agreed with the orders passed in the execution petition number 146 of 2019 dated 19/4/2021. The petition is before this court. The court below, by order impugned, had allowed the petition with cause and directed and also observed that the DHR is entitled to recover EP claim amount of 4,04,333 from JDR as claimed in the EP. Originally, the court by order dated 28/8/2018 had granted an amount of rupees 5,000 as maintenance. Aggrieved thereby, the petitioner has filed a writ petition, that is WP number 3387 of 2019. And this court by order dated 11th March 2018 had
March 2019.
had considered the fact that the matter is posted for judgment and the interim order is coterminous with the main proceedings. Hence, he is not inclined to pass any order. According to the council, that when they have filed a main appeal against the orders passed in MC, now the EP proceedings are not maintainable. Further, EP proceedings are not maintainable. Then council appearing for the respondent submits that after filing after dismissal of the writ petition, suppressing the same, he had filed WP 7053 of 2021 before this court, and that petition also by order dated
9/8/2021, my lord.
dated
9/8/2021.
9/8/2021 has confirmed the order and confirmed the order of granting maintenance of an amount of rupees 5,000. Learned council submits that with suppression of facts, the present writ petition is filed and the same is liable to be dismissed. This court having heard the learned counsel from counsel for the parties and also peruse the material on record. The initially interim maintenance of at 5,000 is granted and later the MC came to be dismissed. From the date of order till the orders are passed in the MC, he is liable to pay the maintenance. And in that regard, EP is filed. That EP is very much maintainable and the court had rightly allowed the petition. And on the face of it, it appears that the petitioner had suppressed the factum of filing earlier petition before this court and also filing of another petition, that is WP number 7, that another writ petition, that is WP number 3387 of 2019, in the subsequent writ petition of WP 7053 of 2021. All these things reveals that the petitioner is coming before this court by suppressing the facts, and in a way, the petitioner is playing with the process of the court. In fact, this writ petition deserves to be dismissed with exemplary cause. However, in the facts and circumstances, the writ petition is allowed, the writ petition is dismissed, and this court finds no reasons to interfere with the well-considered order passed by the court. Next, 35.
Till number 35.
My
Ravi
lords,
Desh, petition.
my name may be shown, my lords.
What is your name?
Charan Sabrad. I appear for counsel on record, Vishwanath Sabrad, my lord.
Yes,
Please, grateful.
yes.
For the petitioner in this case, my lordship, we had called in question the order of visitation passed by the trial court between my lordship. My lordship had interacted with the parties as well as the child, my lordship, on 2 to 3 occasions. My lordship also made certain observations, my lordship. View of those, we would like to withdraw the present petition, my lordship.
Where is the order? Where is that withdrawal petition?
I'll submit a memo of withdrawal, my lordship. Handed.
What is the order passed to the court earlier?
My lordship had sought for the child to be, my lordship had ordered for the child to be given to the father for 3 or 4 weekends, my lordship. It was, the child was given there, but however, the child did not want to go for overnight stays. The order, however, here that the impugned order is only in respect of visitation for the day, my lordship. Hence, I have been given instructions from my client to withdraw the petition, my lordship.
I know. But the conduct of the wife and the mother, and the manner in which she is taking care of the child, I think the court should make for the trial court to decide.
My lordship.
No, the court has interacted. What is the manner in which the boy is brought up, and what is that he is talking to the father, and why is the mother letting him talk like that? Is it right on her part to do all that?
I will advise my client accordingly, my
What
lordship.
was she saying? She was not even stopping him from shouting at him. But in fact, in turn, she says, no, like he's getting very agitated. Let this father be sent out. He's just using the boy to settle her disputes with the father.
Not so, my lordship. My lordship, the father was exercising his visitation right all the way till 31st March 2023, my lordship. My lordship may peruse one document, my lordship, which is the document submitted by the father itself, my lordship, in the statement of objections, 91, my lordship. On 31/3/2023, he submits a certain document to the school, my lordship, which, sets whatever is happening right now into
The
action.
last occasion when the matter came up, then the boy also, father was there. The boy said, okay, if you say sorry to my school teacher, it's fine. But then from there to next, after the matter comes, there is a sea change in the attitude of the boy, which the mother has to answer.
I will advise my client accordingly, my lordship.
And anyhow, all these docket proceedings are there, which the court has recorded, which will come to his rescue. It is nothing but abusing the process of the court. Whatever, when it is convenient to you, come before the court. When the orders of the court are not, you're not happy that the court might pass some other order, then now at that point of time, she wants to withdraw the writ petition.
Not so, my lordship. I have advised my client to maintain the decorum during the visitations, etc., my lordship.
Yes. They want to withdraw the petition.
This is my lordship.
Then let him file no, we'll do one thing. Let him file a withdraw petition, file your objections to that. We'll see.
Yes, my lord, that's because.
Land counsel for
one
the
year I have
petitioner
been
submits
denied
that he
my
wants to
visitations.
withdraw the writ petition, and the counsel for the respondent submits that he'll come up with his objections. Post this matter next week on Monday. Yes.
Oblige, my lordship.
Bill number 36, Gopal Krishnamurthy C for petitioner C Vijay Kumar.
Early hearing.
Lord, last two occasions, my lord, respondent and his counsel is absent. Lordship was pleased to means the pass an order that suppose if he doesn't turn up, then matter will be taken up. My lord. Again, in all the dates, he is doing the same
There
thing.
is no representation on behalf of the respondent on
Two occasions.
on 21/6/2024, and also today on 8/7/2024, and today also. Post this matter as part heard. Anita, part heard is part heard. Let them not keep whatever they want to keep.
Yes.
As part heard on the top of the list tomorrow.
Please, grateful.
Yes, next.
Bill for 37 for orders matters.
Appearing for
P Manish.
petition, I appearing for petitioner in this matter, my lordship. The notice awaits my lordship for the.
Respect to
LR
R5. When was it sent?
I appear for respondent, the contesting respondent.
I paid the process earlier.
You appear for whom?
My lord, I appear for the contesting respondents, my lord, the decree holders before the executing court.
Process date.
Others are not necessary.
Others may not be necessary, my
15
lord.
may not be, my lordship, because she is also JDR.
Then who is necessary?
My lord, the issue is.
R5 A to C is necessary.
R5?
A to C,
is
because they are
necessary.
the.
When is the notice sent to them?
Filed it on 6 February.
I paid the process on 6 February.
21/6. Await service of notice, post after service, post.
My lordship, I pray for extension of interim order, my lordship. Last
Lord, I
occasion.
have serious
could not made an
objections to an extension, my lord. This is a suit, my lord, of the year 1980.
1980.
Please, my lord.
Yes, my lord, that it is
I
their
enjoy
own
a
mistake,
decree,
my
my
lordship.
lord, which is still not
Because
executed. These are these
Honorable
are
Court-
third-party purchasers of a joint family property, my lord.
My lordship, this honorable court granted a decree of partition, my lordship. Instead
It
of,
is not a decree of partition,
instead
my
of
lord.
making an initiating FDP proceeding, my lordship.
Post this matter on 29th. Yes, next.
My lordship, interim order may
Or
kindly be
if it is
continued.
extended on the last occasion, it will be extended, like
My
otherwise.
lord, it is not extended. There is a, they
Then
have
it will
filed an
not.
application, my
We'll
lord,
hear it,
seeking
we'll hear it.
extension.
Yes, then.
Bill number 38.
Grateful.
Yes, non-compliance of office objections.
Yes, yes, my lord. With regard to the non-service of the copy on the caveator, the caveator is already appearing and I.
That is a non.
One, yes, one aspect, my
so?
lord. And beside that, my lord, the copies of the IA and the objection
Number
thereof.
4, rely on this.
Yes, they were not filed because main petition
The
was filed.
office objections, partly hence this file is posted before the portions. Going on further, the council has filed any document relating to the settlement. The petition party complaint. Filed along with statement of objections, IA number 11.
Yes,
To be
two.
filed along with statement of objections.
Yes,
E, F and G to be attested by competent authority.
I'm filing, my lord, right now. I had undertaken before this
Land
one.
counsel for the petition
Yes.
submits that he is, no, file it in the section.
Yes, my
In,
lord, I'm permitted.
he'll file, he'll comply the office objections. If the objections are complied, it post this matter on 22nd.
Much obliged, ma'am.
Yes,
Number
39.
Rajesh P for petitioner.
Yes.
This petition is filed challenging the maintenance order.
Respondent is appeared on the last occasion.
They've taken several dates and I was not given an opportunity to hear on the interim prayer at all, my lords. Two hearings before
Post
they were.
this matter tomorrow. This is also part heard. Counsel for the petition is present, no representation on behalf of the respondent. Part heard tomorrow, top of the list, 739 and 39.1. Next,
Bill number 40.
40 is, I think, adjourned.
That is in.
Yes, 41.
41. Vijay MT.
Petitioner, my lord. Stay the proceedings, trial.
Maintainability of writ petition, what is questioned?
Paper the proceedings, my lord, in.
Not stay for the proceedings, what is questioned before this court? Where is the impugned order?
My lord, in already this one case is before in null and void, my lord.
Please come to the impugned order. What is the case about? It is a final order or interlocutory order? The petition filed with the petition, so you cannot maintain a writ petition. This writ petition, you have to file an appropriate petition. You have to file an RPFC against this.
Yes, my lord.
And then the petition has filed the writ petition against the final order passed on 125 CRPC. The office had taken an objection that the writ petition is not maintainable. Office objections are upheld and the writ petition is disposed of, giving liberty to the petitioner to file the appropriate petition. Yes, 42.
Yeah, the first question.
Yes.
This case, my lord, the husband petition, my lord, the wife has filed the miscellaneous MCM.
On compliance of office objections.
Regarding, my lord, I have given submission, my lord.
Yes, what are the objections? What are your submissions?
They have, we are not relied on the MC entire petition copy and as well as the.
Typed copy of manuscript portion of, so shall I record that you will not rely on those documents?
Please, please.
Next, preamble portion of Annexure E to be furnished and complete copy of Annexure E to be furnished.
Please, my lord, kindly
is
see the
that?
para 43 is very clear, my lord. You have prepared the writ petition on the IA order, my lord.
Then if you don't rely on something, why do you file that when which is not visible?
That's why I have given the submission, my lord. You are not relied on that.
That's why you shouldn't file, don't have to give the submission also.
Please, my lord, but the order, my lord, very clear, my lord.
Stated that the office has raised certain objections. As far as E2, when Annexure E, Annexure B and Annexure E is concerned, he is not relying on.
Please.
And considering the same, the office objections are overruled. Pose this matter for hearing tomorrow, not tomorrow, on Thursday.
Please.
Yes, next. Done? Yes.
My lords, one submission.
Yes.
My lords, serial number 26, my lords.
Yes.
It was disposed of. I am for the respondent, my lords. As per your lordship direction, the petitioner counsel has served the copy on respondent counsel who appeared before the family court, my lords. In high court, my lords, I have not filed the wakalat. As my lords, we have all.
That he has submits that so and so has instructions to file wakalat.
Yes, my lords.
In
And
that
the-
matter, write their name. Write their name.
Yes, my lords.
Anita,
Yes.
get that list. What is tomorrow's this thing and ask her to get it.
K. Prasanna Shetty. K. Prasanna Shetty.
ಕೆ. ಪ್ರಸನ್ನ ಶೆಟ್ಟಿನ ಬರ್ದಿದ್ದೀನಿ.
ಅಲ್ಲಲ್ಲ ವಕಾಲತ್ ಫೈಲ್ ಮಾಡ್ಲಿ.
ಅಲ್ಲ ನಾವು ಗೊತ್ತಿಲ್ಲ ಒಟ್ನಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರು.
ಮೇಡಮ್ 39 serial number.
But we have.